Look, given the questions that fell from the bench on the last occasion, I thought it better, at the risk of adding to the paper before your lordship, of putting in a short supplementary note, just addressing that issue separately on whether a contract is required or not, just to put everything together in one place. So I'm not going to waste my lord's time with things that have already been shown to my lords. But if my lords see the supplementary submissions I put in yesterday,
Part 2
I'll
supplement.
quickly run through those.
Just 1 second,
Yes.
as long as we all have it.
It's
Okay. Yeah,
8
yeah,
pages.
it's a short one.
It's a short one.
Right.
It's only on this limited aspect and one new article which I found which is extremely edifying. I'll go through that. It's a recent article by Bernard Hanisch, who's internationally recognized as the sort of expert on the group of companies doctrine. And he has analyzed the law from all over, including India, and then come out with certain conclusions, which I'll only read the conclusions to my lords. I won't obviously read the whole, it's a very long chapter. My lord, coming back to what fell from my lords, and section 7. My lord, section 7, as we saw last time, and if my lords turn straight to page 2 of my note, where I've tried to break up section 7 in para 5. The first part of 7.1 deals with the arbitration agreement. So there must be an agreement by the parties to submit to arbitration all or certain disputes. And 2, the arbitration agreement must be in writing. That is in 7.3. Now that ends, in that part of 7.1, it ends arbitration. That is a concluded contract. That is required to be a contract. I'll show that. What are the nature of the disputes that can be referred to arbitration under that contract? Then follows. So the disputes could be past or future. The disputes must be in respect of a defined legal relationship. And the disputes could either be contractual or not. And in fact, if my lords would kindly, there's a short compilation with this, a new compilation of authorities, page 141 of that, there is a passage from Russell, which actually puts it very nicely. It's just a sentence I want to read from there, but it really puts it in encapsulated.
Where is that compilation?
What is the compilation? It's called SCC. Part 2 of my compilation. It was filed with the note.
Oh yes, convenience compilation.
Yeah, these are more inconvenience than convenience, I agree with what, but they're always for some reason called.
It is, it's
So page 141.
Was it the supplementary convenience compilation?
Yes, that is the
Convenience.
supplementary.
477 pages.
141, if my lords think I. Page 141 of the compilation.
Page?
Page 141 of that supplementary compilation.
Page 144 PDF.
Yes.
Definition, it says statutory definition of arbitration agreement. This is under the English Act, no doubt. It says definition in the 96 Act.
140?
My lords have that. Section 6 of the Arbitration Act 96, that's the UK Act, contains a definition of an arbitration agreement. It provides that an arbitration agreement is, quote, an agreement to submit to arbitration, present or future disputes, whether they are contractual or not. And then the next sentence. An arbitration agreement is therefore a contractual undertaking by 2 or more parties to resolve disputes by the process of arbitration, even if the disputes themselves are not based on contractual obligations. I would adopt the same submission for our section 7.1. The agreement is a contractual undertaking. The disputes themselves may be contractual or non-contractual. There may be family matters, partition. But to go to arbitration, there must first be a contract. It's not that every family dispute without an arbitration agreement can go to arbitration. There has to still be an arbitration agreement. Similarly, for all the other examples that fell from the bench, torts, quantum meruit, quasi-contract, it requires an arbitration agreement. Now, the fact that an arbitration agreement has to be enforceable in law and therefore a contract, there are several tools that we get from the mathematics of our own. The most important tool to my mind is found in section 28 of the contract. My lords know section 28 of the Contract Act renders void
Contract.
any contract in restraint of legal proceedings.
Arbitration is an exception.
Exception, and it's referred to as a contract.
One point of distinction so far as the UK law is concerned, they have a separate statutes with respect to rights of third parties.
Yes.
So therefore, that's the point of distinction.
My lord,
Our law in the English.
so do we, and our act deals with that. I'll show that provision also. My lord is actually statutory arbitrations. We also have. If my lord sees section 28, agreements in restraint of legal proceedings void, and exception 1. I'm sorry.
Yes.
Exception 1. This section shall not render illegal a contract. Please mark those words. A contract by which two or more persons agree that any dispute which may arise between them in respect to any subject or class of subjects shall be referred to arbitration. So it has to be a contract, otherwise it will be hit by section 28. And contract in the Contract Act is well defined. That is an agreement enforceable at law. How is an arbitration agreement enforceable? And which is the law that enforces it? It's the Arbitration Act. Because under the Arbitration Act, one can enforce an arbitration agreement either by filing a Section 8 application or a Section 11 petition to your lordships or to a high court. And the resultant enforceable degree, Section 36. Similarly, a foreign arbitration, the foreign award is enforceable under 46, 48. So it's enforceable at law. It's enforceable under the provisions of the Arbitration Act itself. And therefore, it is a contract. And if it weren't a contract, it would fall foul of section 28 of the Contract Act. So it has, and my lords have repeatedly said, and my lords are familiar, I'm not citing those judgments, I've referred to a few of them. Vidya Drolia is the last expression of that it has to be a contract, meeting the requirements of the Contract Act. Your lordships in Bhavan Construction, a judgment I put at page 128 of this. Justice Roy was a party to that judgment, also says that arbitration is a creature of contract. Correct, absolutely correct. And then if my lords go to page 3 of the note, running through it, all the material, I don't want to trouble my lord by actually reading everything. So, para 13, I've cited the US Supreme Court. A party cannot be required to submit to arbitration any dispute which he has not agreed to so submit. And it refers to it as a matter of contract. Then Russell, I've shown my lords. And Gary Bourne also says this is a contractual method of resolving disputes. So there can be no doubt that an arbitration agreement has to be a contract. Otherwise, it's meaningless, not enforceable. It would run into the restraint of section 28. The disputes that can be referred under that contract can be non-contract, no question. Tort, family disputes, even IPR disputes of a certain nature, all that can be. And then at page 3 of my note, I've now analyzed what are the requirements under the Contract Act of a contract. The first is, your lordships in have said this, that mere acquiescence is not enough. There has to be an offer, acceptance, a proposal, and acceptance. And therefore, there has to be reciprocal promise. There has to be an absolute and unqualified acceptance, which has to be expressed in a usual and reasonable manner. Why am I emphasizing this? Because as far as the signatories are concerned, they've signed. That's the acceptance. There's no dispute on that. As far as the non-signatory, the non-signatory's acceptance would have to be established in a manner known to the law of contract. That doesn't mean signature. It can be by conduct also. Because acceptance can be by conduct. There's no difficulty on that. But it has to satisfy the threshold of what constitutes acceptance under the contract. Now, all this actually does tie in with the group of companies doctrine. I'll come to that finally. It's not that this takes us away from it, but it definitely requires a scrutiny of the factors that satisfy the group of companies doctrine through the lens of the contract.
Mr. Kambata,
Yes.
this group of companies doctrine and you have actually defined legal relationship
Logic.
and a non-signatory doctrine. When you talk about group of companies, there are promoters for a company. Promoters may not be taking a decision for company X,
Logic.
but the promoters are of company X, Y, Z.
Yes.
Now, perhaps an attempt is being made that the promoters who might have been, looking at the promoters, people might have entered into contract with, say, company Y.
Yes.
Promoters are also being looked in who otherwise have no connection, nor they are significant.
Correct.
So, what is the interplay? Perhaps in a company situation, there's a board of directors which take the decision.
Logic.
Would you like to sort of?
Yes, Manoj, I think that's a very good question. And maybe go straight to page 7 of this note. I've actually addressed this very issue. Fell from my lord on the last occasion. Therefore,
That's why it was.
I have
something-
addressed it not
Okay.
specific. We can go to it straight away.
No, you may go in your own flow, but
My lord,
You should.
I don't mind going to it straight away.
No, no,
because
you
these
may
are
go in
issues
your-
that arise.
go in your own flow and then come to.
Very good. I mean, I'm certainly going to address it.
Right.
It's a very important aspect. You know, coming back to where I was, therefore, 24 of my note, para 23, consent as defined under section 13 of the contract. Two or more persons are said to consent. They agree upon the same thing in the same sense. Consensus ad idem. So, in the para 24, I've tried to summarize. In the context of the group of companies doctrine, one, there must be consensus ad idem. That is a mutual intention on the part of all parties, both signatories and non-signatories, to be bound by the arbitration agreement. Two, there must be absolute and unqualified acceptance by the non-signatory. Three, this acceptance may be expressed or implied. Usually in the context of group of companies, it is likely that the acceptance will be implied. Such implied acceptance manifests in negotiations, performance, and termination, if applicable, of the contract. And that is why, my lords, in the ONGC discovery judgment, have added a very critical fifth factor to chlorocontrol. It was not there in chlorocontrol, it's performance. That is a fundamental factor. Then four, such participation in the contract through negotiations, performance, and termination, if applicable, must absolutely and unequivocally show the non-signatory's acceptance of the contract as a veritable party to the same. In other words, and this is put very well by William Parr in a passage cited in Cox and Kings, where he says, the fact that a non-signatory might be bound to arbitrate does not dispense with the need for an arbitration agreement. It only means that the agreement takes its binding force through some circumstance other than the formality of signature. So you still need a contract, but you need not have a signature, because you can say that a party has orally agreed to an arbitration in writing, if it is undisputed and proved, or by its conduct in negotiation, performance, taking on of obligations, has effectively and impliedly consented or accepted that arbitration agreement. So I'm not for one moment suggesting that this argument excludes the group of companies doctrine. Of course not. Because this is now my alternative argument, that even if space is found within section 7, there are still certain cardinal limitations. And the reason why I'm emphasizing this is that our country, India, has actually gone to an extreme with respect to the group of companies doctrine. We see the law from all over the world. It is hedged in with guardrails and restrictions. India is perceived as they call it, the most liberal as far as this doctrine is concerned. Now, that's not a bad thing in itself. One must keep in mind that going to one extreme will also open floodgates. And India will thereafter not become attractive as a seat for arbitration for example, a group or a foreign multinational or even an Indian multinational with companies where it wants to have a structure where it ring fences certain companies with the contract. They have nothing to do with the contract. But because of the manner in which some of our High Court decisions reached out, any credit-worthy member of the group is brought into the arbitration. So that is, my endeavor is to satisfy my lords that there is need now for some guardrails to be put on the chloro-control doctrine. It cannot be unrestricted or unqualified. That is actually something that works against arbitration. Because the general impression of the other side is group of companies doctrine, pro-arbitration, we must propound it. No doubt about that, but with certain guardrails. Only then will it become an effective doctrine. And guardrails to the extent that it cannot intersect and be destructive of other very well established, like the right of a corporate group to structure itself, short of fraud circumvention. I'm obviously not talking about those cases. Those cases, my lords have always been able to look through, always pierce the corporate veil. So fraud, deception, circumvention are out. But short of that, there's no reason why, as in tax planning, one can't arrange one's affairs. The whole line from our Constitution Bench decision in Dunlop, and then as explained in Azadi Bachao, saying there's no reason why you can't organize your affairs. Now, giving unrestricted vent to the group of companies doctrine will ride a coach and forth through all those other doctrines. Therefore, the doctrine of concluded contract will go. The doctrine of structuring your affairs in a particular manner will go. The doctrine of party autonomy and consensual nature of arbitration will go. If the group of companies doctrine is interpreted as so far-reaching as to reach out to any part of the group. And that's the reason why I would submit that it is necessary for your lordship now to lay down this stuff. It's not enough to say that there are judgments Supreme Court and that's enough, which is what my learned friends say. Oh, so when we see those judgments, and I'm not going to trouble my lords with those, everyone has read those, they don't have these guards. They are even chloro controls. For example, chloro control is the most important guardrail of performance. It's not there. So it is necessary. Now, may I just show your lordship judgment in ONGC and Discovery, which is in my main compilation at page 838. The first compilation that I filed, volume 1.
Just one second. ये कहाँ पर होगा?
Page 1.
Yes, that yes. At 805. Forty 41, which start at running page 845.
1 second. Just still.
Violations that you have
I
filed
filed.
in your office.
One
What
was the
page?
long one,
805 PDF.
with what 1500 pages.
Yes.
And then second is yesterday's.
That's
The length is only because we put in the entire document actually.
Convenience compilation, yes. Page 805.
805 at 845 is para 40. It actually neatly summarizes chloro controls and adds one factor. So at the bottom of page 845, in deciding whether a company, whether within a group of companies which is not a signatory to arbitration agreement, would nonetheless.
Just 1 second.
I'm so sorry.
PDF 849.
Para 40 at page 845 of the compilation.
Yes.
May I read that?
Yes.
In deciding whether a company within a group of companies with a signatory agreement would nonetheless be bound by it, the law considers the following factors. 1. The mutual intent of the party. 2. The relationship of a non-signatory party to the signatory. 3. Commonality. 4. Composite nature of the transaction. And 5. The performance of the contract. This last factor was not referred to in Chloroquine, but it's a critical factor for all the authorities, because it is this that would make the non-signatory a veritable party or give unqualified implied acceptance. And then para 41. Consent and party autonomy are undergirded in section 7 of the 96 Act. However, a non-signatory may be held to be bound on a consensual theory founded on agency and assignment, or on a non-consensual basis such as estoppel or alter ego. Now, I'm not dealing with these because I believe my lords are really looking at the group of companies law. These theories are well settled. I'm not addressing on these theories. But when my lords say consensual theory, that necessarily means consensus ad idem under the Contract Act. Now, not two important documents which I've put in my, sorry, take my lords back to the short compilation, the recent one. The first is a report of the Secretary General of the UN. That is found at page 198 of the short compilation.
Page.
It starts at 194, page 194, but at 198. At 194, we see it is a United Nations Commission on International Trade Law, Settlement of Commercial Dispute. Topic is requirement of written form for arbitration agreement. And if we go to 197 first, para 12, gives various fact situations where parties may be said to have agreed to an arbitration clause. 12 APC is a number of situations different types of situations. And if we go to the next page, M, where a claimant seeks to initiate an arbitration against an entity not originally party to the, or where an entity not originally part of the arbitration agreement seeks to rely on, initiate an arbitration, for example, relying on the group of companies theory. And if my lords kindly see the footnote, footnote 1, the group of companies theory has been used to bring a parent company or a subsidiary under an arbitration agreement, which has not been signed by other members of the group. The theory may be summarized as requiring that the legally distinct company be brought under the arbitration agreement, group of companies that constitutes one economic layer. 2, that the company played an active role in the conclusion and performance of the contract. Active role in conclusion and performance. And 3, that including the company under the arbitration agreement reflects the mutual intention of all the parties. This concept has been applied in a number of arbitrations. For example, those some jurisdictions have rejected even this. But this is the UN law, and then, my lord, a very, very instructive law by Bernard Konishi, which is found at page 208 of the same compilation. And for about 50 pages, he conducts a review of all the jurisdictions, 2020, including our courts. And at 258, 259, I conclusion placed before my lords is my signature. 258. I'm sorry.
258 will be part of the same article.
Same article. The conclusions in the article. It's para 487 onwards.
258, is it?
258.
269.
261 is the PDF.
Section 4 conclusions. It's just 2 pages and may I just, because he's really summarized the doctrine. It is very difficult to draw general conclusions from the above survey of the case law. Extension of the arbitration clause to other companies of the group, non-significant in France, and still today, its courts and arbitrators are amongst the most innovative in the development of this jurisprudence. On the other hand, Swiss courts appeared in the first place, extremely reluctant to accept the extension of an arbitration clause to non-signatories, but the Swiss Federal Court has considerably relaxed its jurisprudence. The German approach still appears very restrictive. The courts approaching Holland, Russia, and the People's Republic of China. This seems to be also the position in England, where the so-called doctrine of group of companies is set with the principle of privity of contract, the principle of corporate, the treatment of derivative act. Moreover, the principles of lex mercatoria are not part of the English law. The issue of who is a party to the arbitration clause is therefore mainly viewed as an issue of consent, but extension may nevertheless be achieved by recourse to such other theories as agency, trust, or in the corporate. The same theories are also applied in the US, which to some extent appears to be one of the most liberal jurisdictions with respect to the extension of the arbitration clause to non-citizens. India being definitely the most liberal of all. Then para 488. Subject observations. A first conclusion may be, now we're not in the subsequent paragraph, identified 9 factors that, or 9 points that he identified.
I think it's cyclical, you know. We took a beating in ONGC versus SOPI,
So nice.
and therefore, you know, we have now turned the pendulum.
But I,
Incidentally, who was reversed in ONGC versus SOPI?
Justice Ilse and then Justice.
No, it was my judgment which was reversed.
Oh, okay.
ONGC versus SOPI.
Uh,
I had upheld the award and I was reversed by the Supreme Court. I was reversed in ONGC and I was reversed in Vodafone. Vodafone still holds the law.
I think the appeal court in ONGC SOPI was Justice Pensy and Justice upheld my laws. Then it went down.
Sorry. I was reversed when there was a young law student from one of the national law schools, and she called me up and said, I want to interview you about ONGC saw pipes. So why on earth would you like to interview me on ONGC versus? Because you were reversed. I said, good heavens, judges have nothing to do with
That's
whether,
very PRP.
how you feel when you are reversed or something.
That's right, exactly. Exactly. Your lordships, I say, well, once your lordships write a judgment, then it's not. I mean,
I
it's,
was sitting with Justice Pandya of the Gujarat High Court. He had just in Pandya, he was our acting chief justice.
that's right. Your lordships were sitting with him for quite some time. Even the backup to the BPT
Right.
rent was done by your lordship.
He was the ACJ who swore us in actually when we came. That is Justice Hubde, Justice Khanvilkar and I in 2000.
The law student might have been thinking. But the
There's
judge,
some fulmination which I then used to get TRPs. You know, here I've identified 9 factors, and each of them is very instructive. He really summarizes the whole theory in my respectful submission very well. I just them and I'll try and identify.
Gambata, in this article, has he identified any points of distinction in the law that is applicable to India and other countries? It's
Yes.
clear that, there are certain aspects which are distinct.
No, that's,
Contract as well as an more
In that-
particularly contract.
my lord is right. Therefore, 487, he's already given the seat. So English law is very strict, privately, will never accept it. So they've rejected it.
It's because they have an act.
No, that
I
is
have a
because
doubt on.
they rely on their common law principles of contract and peer. They jealously guard those. So they say there's no scope for an exception to those. And they see the group of companies doctrine as some kind of an exception to those doctrines. Even the US, I'm going to point out a nice article, my lord, where I cited a number of theories.
And Dow specifically referred to performance.
Yes, absolutely.
That extract from Dow, which Hanitu has quoted, just at the bottom of page 258. Again, just to go back to that,
Correct.
the question whether persons, I presume that's the citation from Dow.
Dow, yes.
Dow. The question if the agreement can take advantage of an arbitration clause therein. It's a matter which must be decided on a case-by-case basis, requiring a close analysis of the circumstances in which the agreement is made. So making corporate and practical relationship existing on one side and known to those on the other side of the bargain, the actual presumed intention of the parties as regards the rights of non-signatories to participate in the arbitration agreement, and the extent to which and the circumstances under which non-signatories subsequently became involved in the performance of the contract.
Sure, I'm corrected. It's not Dow, it's some other.
not Dow.
Dow also has similar
It's
language.
not
talks
Dow,
about
this was about
footnote
But there's similar language.
512 says 30th November 1998, published, unpublished. See also ICC case number.
In fact, now there is a very strong move for publication of awards
Yeah.
because of all this.
to add some
But
transparency.
then, of course, confidentiality is the factor that was
You can
around.
always redact and
That is the move that most institutions are now making. But let's try the 9. First is, as my lord has said, in that extract, actual or presumed intention of the parties as regards rights of non-signatories and subsequently became involved in the performance of the agreement and in the dispute, both.
actual or presumed.
Actual or presumed intention of the parties as regards the rights of the non-signatories to participate in the arbitration agreement. And the extent to which and the circumstances under which non-signatories subsequently became involved in the performance of the agreement and in the dispute arising from it. And that's why it has to be on a case-to-case basis, because each case will be a different.
But which are the 9 factors?
Yeah, so, well, I have taken this as one factor, but my lord is right, there are probably 2 in here. It's intention as well as performance and dispute, so that's really 2 factors there. Then 489, a second related conclusion is that arbitral tribunals do not often base their decision to extend the clause or not on a prior determination of the applicable law. Even if they do determine the law applicable to the contract and or the arbitration agreement, that law does not necessarily play a major role in the final determination of the non-signatory issues. Starting from the principle of autonomy of the arbitration clause, arbitrators generally feel free to determine their competence according to what they consider to be on the basis of the facts of the case the common intention of the parties, also taking into consideration usages of international trade. So that's really the same as intention, common intention. Then 3, there is also an agreement that the existence of a group of companies is not per se a sufficient element to allow extension to a non-signatory of an arbitration agreement concluded by another member of the group. This is a very important doctrine. Because often tribunals, I've found, they see a group and they say it's a group of companies. We just draw in whoever we want from that group. That's not enough. A number of other factors work on that decision. So they say existence of a group is not per se a sufficient element. Then 491. In most cases, courts and tribunals require proof of the existence of an intention, at least implicit, of all the parties, that the non-signatories be parties to the underlying contract and its arbitration clause. Some courts, however, limit themselves to an awareness of the clause and the requirement that the additional claimant or defendant be concerned by the dispute. But the company concerned must always have played a role in the conclusion and performance of the agreement, and this has to be proved by the party requesting the extension of the clause. And beyond actual or implied consent, many cases are also simply decided by reference to other theories of civil or company law, and that's the first. That is agency, piercing the veil, etc. Then 492. The analysis of the arbitral awards also leads to the emergence of a rebuttable presumption that a parent company binds its subsidiaries. But that, however, only companies that have participated in the conclusion and performance of the agreement will be bound by the contract and the arbitration clause. This rebuttable presumption is quite similar to what our Supreme Court said in Vodafone, that even if it's a wholly owned subsidiary, you still have to show control. But it's a rebuttable presumption that you will have control with your shareholding. But that's not enough. You still need to show the subsidiary participated in the conclusion and performance. Then 493. Various other elements equally play a role in the decision to extend the clause to a non-signatory. First bullet point. The fact that the other party has obviously entered into the agreement with the group as a whole and did not really care which companies would be involved in its performance, assuming that the determination of the signatory companies only concerned the details of performance of the contract. That's straight from the top. They didn't care which part of the Dow group was the actual signatory, because they were dealing with a number of Dow group companies. Or the next bullet point, the fact that all the companies concerned have participated in the rights and obligations of the contractual relationship, in what is sometimes being called a total confusion. So there must be rights, there must be obligations of the non-signatory. He can't just be drawn in because he's part of a group. And then if we go straight to para 496, 494 refers to lifting of the corporate veil. 496, arbitral tribunals and courts have also emphasized the right to use a group structure as appropriate. But once a choice has been made, it must be fully assumed. In this respect, the use of a company vehicle for tax or other reasons is not per se an argument to justify lifting the corporate veil and, for example, extend the arbitration clause to the underlying shareholders as additional claimants. This is again very much part of our law. As I said, in Azadi Bachao, Vodafone, they've all respected this. If there's fraud, circumvention, of course, but not otherwise. And then 497. It seems that at least in a number of cases, a good test to decide whether an extension of the clause is appropriate is to determine whether the same solution would be justified if the situation was reversed. In other words, it is tentatively suggested that the principles used to determine the eventual extension of the clause to additional defendants might also be applied with some caution, however, when the case concerns additional claimants and vice versa. In fact, in Dow, it was the non-signatories who sought to be joined as claimants. So when a tribunal says, group of companies doctrine, this company A, we are joining as a defendant, it must apply its mind. Would we have allowed it to come in as a claimant? Same test must apply. And it has to, because even when you bring in a defendant, there can always be a counterclaim. So it has to be a reciprocal test. It can't be that you just look for the most asset-rich company of the group and go for it. Would you have allowed that asset-rich company to have filed a claim against that claimant? That's a good test. None of these, it's not, he doesn't say that each and every one of these factors has to be met. But he certainly suggests that a large number of these have to be met. And merely being part of a group is not enough.
You identified
Actually,
about
you
9.
know, I'm not sure the performance in all cases is necessary, because it could be that, you know, a party, for instance, says that, look, you enter into a contract with my subsidiary. I'm the developer of the
Yes.
software. I'm the creator of the technology. And therefore, my subsidiary is basically going to be selling you what I have created and I have developed. So the third party who enters into the contract, the contracting party which enters into a contract, relies on the representation which was held out by the parent. Eventually, the parent may just step back and say, look, I'm not participating in the contract.
Yes.
So the claim really is for breach of the
Representation.
obligations.
Correct.
Then in which case, the fact that the parent did not participate in the performance of the contract may not be itself very
Correct.
exquisite.
But therefore, that's where, in fact, there's a good article which my lord has
So
written.
these are circumstances in mind.
My lord.
I'm not sure whether they should be treated as cumulative, because then we'll be unduly restricted.
No, of course not. Of course not. That's not the submission. But a large, the test is really, does it meet the Contract Act threshold for implied acts? If it does, then the contract. It may be that in a given case, just one of these is enough to constitute implied acceptance. It could be. But it must ultimately meet the test of the Contract Act Section 7 read with 13. Was there an intent to unconditionally accept the arbitration agreement and the main contract? Because what is also now happening is another complication. Parties are being joined to arbitrations on the footing that they are parties to the arbitration agreement. But the question of liability under the main contract is being left open. So you may have a situation where you join a party, participates in an entire arbitration, having to read evidence, etc. And at the end of the day, it's found that the contract doesn't hold him liable to anything.
So, Mr. Khambata, the first point which we identified was the actual or presumed intention of the party has rights of non-signatories to participate in the arbitration agreement. Right?
Yes.
Second was participation in the execution of the contract.
Yes.
Third was participation in the performance of the contract.
Yes.
Which are the other features then?
Yes. The second is performance and in the dispute also.
Participation in the performance.
Performance and dispute. There must be some, as my lord said, the dispute must be that you made the representation to me. Therefore, that is the dispute. It can't just be, because equally the flip side
Then
is,
there's a third. Then what else?
then if you go to the next page, para 49, just because there is a group of companies is not per se a sufficient element on its own. Then 491 really goes back to reiteration of performance, role in performance that we've seen. But if we see 492, the fifth factor, rebuttable presumption if it's a subsidiary, but provided that subsidiary participated in performance of the contract. Then 6 and 7 are found in para. That the party did not consider or care really. That's the example that fell from my law. That it's a group, you're really dealing with the essential party, you don't care who actually signed. But that has to be proved. It can't just be us. Then 7 is that all the companies concerned have participated in the rights and obligations of the contractual relationship. That's the underlying contract. Must be rights and obligations. My lord has referred to a theory of estoppel, the benefits estoppel theory in America. So if you get benefits, then you are estoppel. But here for group of companies, it's rights and obligations, both of the underlying contract. Then factor 8 is in para 496. The right to use a group or corporate structure. That is respected. It's not that that is just overridden. Because you may, with open eyes, contract with one member of the group, knowing that the technology comes from another member. You don't insist on contracting with the other member. Later on, you can't say the other member is more creditworthy, therefore I'll go against it. And 9 is, does it the test work both ways? Would you have made this person a non-signatory claimant? Would you have allowed it to claim against the signatories?
That's the 9th.
So that is the 9th, the last paragraph, the reciprocal test. Would you have allowed it to claim?
The 8th one.
Case by case.
Yes,
Because
correct.
in a given most important 490, that merely because
Yes, repeat the 8th point.
the 8th one is in para 496, that there is a right to use a group structure. They recognize a right.
Okay.
Otherwise, the whole basis on which today in the corporate world, including within India domestically, companies are organized would be. And I just want to point out why one has to be a little cautious. The author analyzing American case law has said there are two theories of estoppel. Benefits estoppel, where you get a benefit but you keep out. There he says the non-signatory can be better. But intertwined estoppel, which is like our composite performance, he says that can be used against a signatory, not against a non-signatory.
This is important.
Because he's not fair that a signatory portion. Now, my lord, with that, may I go to the promoter's point? Because I think that is a point that
But you are
one of-
telling us something at 417.
I'm sorry.
You are showing us something.
Yeah, I'm sorry. May I just show that? I'm so sorry. 471. I should have shown that.
That's an article in your.
That's an article which is relied on by our lordships in.
John Felazar.
That's right.
That's
But he was a colleague of mine during the LLM. Now, the first paragraph. This article is about non-signatories to arbitration agreements. The issue I address concerns a difference in the approach taken by US courts when a non-signatory seeks to rely on an arbitration clause against a signatory versus when a signatory seeks to rely on an arbitration clause against a non-signatory. When it comes to one particular non-signatory theory, the intertwined claims estoppel theory, US courts hold that a non-signatory may rely upon an arbitration clause against a signatory, not the other way around. Now, he gives a reason for that. And that reason comes at page 473. On the third column. and then going on to 472. 473, the second last para starting, it is submitted therefore that the rationale for the intertwined estoppel theory has little to do with estoppel, as it is traditionally understood, but rather is to ensure that parties to arbitration agreements do not undermine their effectiveness by commencing collateral litigation about disputes subject to arbitration. After all, when parties commit themselves to arbitration, they are agreeing to resolve a dispute by arbitration instead of litigation. If parties to arbitration agreements were permitted to avoid their obligation to arbitrate by suing a non-signatory on a claim intertwined with a dispute governed by an arbitration agreement, this would undermine the viability of the arbitration process. What would be the point in agreeing to resolve a dispute by arbitration if full-ball collateral litigation were an inevitable feature of it? While this account of the rationale for the intertwined estoppel theory makes sense as a matter of policy, it brings us back to the fundamental question that we raised at the outset. Why does the intertwined estoppel doctrine operate as a one-way street, stopping only signatories but not non-signatories? After all, if a signatory should be compelled to arbitrate with a non-signatory, when the dispute between them is intertwined with a dispute subject to arbitration, why not the other way around? The reason lies in the foundational principle of arbitration, namely, it is a matter of consent, not coercion. And therefore, he says, by signing an agreement, you have consented. You can't then back out of it. The non-signatory has not consented unless you establish his consent independently of this doctrine, of course. Now, my lord, to proceed now to the very good question on promoters, my lord. Well, I've covered that in this very note at the bottom of page 6. And in para 32 of the supplemental note, I have referred to the doctrine of single economic entity. In my previous note, I'd shown the varying views that different jurisdictions have on this. It's not a universally accepted doctrine. But even within our law, it is well settled that persons are entitled to arrange affairs of its group within the confines of applicable law, as long as such arrangement is bona fide and not with a view to circumvent the law. And that Vodafone, and well, of course, Azadi Bachao, albeit in a tax planning sense. So as long as there's no fraud or circumvention, that's perfectly permissible. And then, therefore, the court. No, yes, I'm sorry, I stand corrected. There's a mistake here. Would my lord please note this is not a quotation. Even though it's an item, this is my submission. It's come incorrectly at top of page 7. My learned junior rightly points out. It should, because there's no footnote, or it really should come as my submission. It's not a quotation. Thus, where there are pre-existing companies forming part of a group, a phrase used colloquially, and contractual obligations are assumed only by certain companies forming part of the group being a signatory to the arbitration agreement, it would be impermissible to join a non-signatory forming part of such group to the arbitration proceedings without the non-signatory having voluntarily assumed the obligation to perform the terms of the contract and having assumed the mantle of a veritable party. This is a key ingredient. That's my submission. That's not a quotation. Now, my lord, the question that fell from Justice Roy is squarely answered in my respectful submission in para 35 of this note. My lord put to me, and this is a question that Justice Suryakant had also posed in Cox and King, that you have family companies. You have companies where promoters are controlling a whole group. So can you reach out to the promoter? Can you reach out to companies within the group? Now, there are a few cardinal principles have to be kept in mind. First is that the ownership of a company, shareholding, is distinct from its management, which is the board of directors. And that, of course, for LIC Escorts downwards has my lord held that principle very squarely. They're two separate organs of a company. But who has the right to actually administer and run the company? That's the board of directors under section 179(1). Promoters are not given such a status under the Companies Act. Many obligations are imposed on promoters under the Companies Act and other statutes like SEBI, but they are not conferred with the right or the status of control per se as a promoter. If they have a sufficient shareholding, then as Escort says, you can remove the board of directors, appoint your own board of directors. But the company is run through its board of directors. So to reach out to a promoter would really require a piercing of the corporate veil. It's not part of a group of companies approach. It has to be then a piercing approach that you form this company as a matter of fraud or circumvention of the law. You are the alter ego and we are reaching through. That is always permissible, but it cannot operate under the group of companies which respects the corporate way. In subparagraph 3, I have said a promoter does not ipso facto control a company, and there are several sections of the Companies Act which show that. I don't need to trouble myself. Then not 4 is very important. This would a for sure apply to large public and listed companies, since the doctrine of identification does not apply to such companies. Now, this in the Reliance matter, if my lords would kindly see in the compilation. This is a very salutary principle, because what happens is sometimes promoters in family companies enter into family arrangements or deals with members of their family. Now, if that concerns shareholdings, even large shareholdings in listed companies, the question is the listed company bound by that? Are they identified with their promoters? And your lordships have had no. If they are public and listed companies, you can't just identify them with the promoter because there's a large body of public shareholders. Because tomorrow, if that identification is permitted, a family member will say, I am entitled to enforce the rights I have against the company, and the company must comply, which is a public company. And therefore, in the Reliance case, I'll just see that in my compilation at page 1457, the big compilation. It starts at 1415 of the big compilation. And the first relevant para is para 58 at 1457.
Yes, the brothers, right.
58. Firstly, the MOU is not technically binding between RIL and RNL. It is not in dispute that the MOU is between 3 persons, and the personality of the company must be construed separate from these persons. The principle emphasized by senior counsel, i.e. doctrine of identification, may be applicable only in respect of small undertakings. But in the case of RIL and RNRL, the companies have more than 3 million shareholders. In such a situation, one cannot make the company's personality the same as that of the persons involved. And then at page 1519, paras 310, 311, senior counsel went to some lengths in arguing that the doctrine of identification has immediate and crucial relevance in this case. As explained by him, there are certain individuals who are the controlling mind of the company, and that once they have agreed to something, it should be deemed that the company also agreed to the same, including the board. Reliance was placed upon the decisions referred to in the summary of submission. In the instant matter, his argument was that inasmuch as MDA had agreed to the gas supply agreements as provided for in the MOU, it should be deemed that the board and the company also agreed to the same. Consequently, his argument is that the MOU is binding on RIL. We disagree. The doctrine of identification as developed by the courts is typically applicable in criminal and tortious liability cases. Even assuming that it is applicable in matters such as this case, nothing really turns upon in the factual matrix of the case. It is the fact that the board in mid-2004 had vested a substantial portion of its powers on MDA, but retained the powers that only it could exercise. The crucial fact is that ADA had agreed that the agreements entered into with MDA as a part of the MOU be mediated through the board in the form of a reorganization, and the board thereafter acted independently. This is amply evidenced by the board insisting that government approval is necessary. So again, on a case-by-case basis, but where the board retains its independence, it can't just be bound by a representation or an agreement by its promoters. Because in that sense, the promoter has obligations, but he doesn't have the right of control. And he can't bind a listed company or a public company. Therefore, this, my lord, is the answer to promoter. Now, may I take my lords only to a few more things, or not, I'll be done. So, one of the other clues on promoters is something I've dealt with and set out in my main submissions, which is under the Specific Relief Act, Section 15. Under the Specific Relief Act, it is expressly enforceable to enforce a pre-incorporation contract made by the promoters against the company. My lord, would kindly see section 15 of the specific relief act. Fifteen, who may obtain specific performance? Except as otherwise provided by this chapter, the specific performance of a contract may be obtained by A, any party, B, representative. And if we go straight to H, when the promoters of a company have before its incorporation entered into a contract for the purposes of the company, and such contract is warranted by the terms of the incorporation of the company. So the company can take advantage of a pre-incorporation contract entered into by its promoters. The flip side of this is in section 19. Who can enforce it? Against the company. When can it be enforced? Against the company. So 19, except as otherwise provided by this chapter, specific performance of a contract may be enforced against a party, etc. And then we come straight to E. When the promoters of a company have, before its incorporation, entered into a contract for the purpose of the company, and such contract is warranted by the terms of the incorporation, the company. So if the promoter pre-incorporation has made representations, entered into an agreement binding the company, that can be enforced against the company. But post-incorporation, merely because the promoter has even entered into an agreement which purports to bind the company, that's not good enough. And every party contracting is deemed to know the law. They know the promoter has no right or authority in law. They know it's only the board, unless the promoter has a specific power of attorney, which is of course a different circumstance completely. So the concept that once a promoter has made a representation or an agreement, the company is bound, may apply to a very small company where the promoter is held to be the alter ego. But the moment it is a public limited company or a listed company, and there are public shareholders, that umbilical cord is broken. It can't be imputed to the company. Apart from which the board now has requirements of independent directors, etc. I mean, there are a couple of other points that may arise. It fell from your lordships, I'm told, the impact of sections 91 and 92 of the Evidence Act. Very because as far as signatories to a contract is concerned, is concerned, it's very well settled that that intention has to be garnered from the contract itself. And if my lord kindly turn to my main note, the first submissions at para 67, page 17. I've just analyzed and summarized the law there. Para 67, it is well settled that the intention of the signatory must be decided primarily from the language of the contract itself.
Which page are you on?
Page 17 of the
Original
main submission.
Yes.
I've cited just the judgment in Bangalore Electricity Supply Company.
Yes.
Intention of parties must be understood from the language they have used, considered in the light of the surrounding circumstances and object of the contract. That's very well said. So as far as signatories go, when you're asserting mutual intention, one will look at the contract. You can really not look outside the contract or add a term to the contract.
Yes.
Or but as far as non-signatories are concerned, like they've not signed it, that may not be a repository of their intent. So it's only for non-signatories that all these factors then come into play. Now, why is this important? Because if in a given contract, the signatory's intent is garnered from the contract as limiting the arbitration to the signatory parties. For example, if the clause says between the executing parties, disputes between the executing parties, or between the parties, and parties is a defined term and is defined very clearly. It's then not possible to impute all these factors to impute an intention on the signatories. And the doctrine requires mutual intention of not only non-signatory but the signatories as well. Everyone has to have the same mutual intention. There has to be a consensus idea. So the means of ascertaining that is different. Signatories has to be ascertained from the contract, and 91, 92 would not be a bar where the intent of the non-signatories. But it would be a bar where the intent of the signatories. And which is a critical component of establishing mutual intention. Page over at page 18, I've made one other point. It's just to put it in the perspective. My lords have, in decisions, very clearly, in para 70 of my note, laid down tests for even implying a term into a contract. So they're very rigorous tests. The official bystander test, the penta test in NABAPA, etc. Now, if that is the level to which a test is applied for implying a term, then surely implying consent of a non-signatory has to at least stand to some rigor. It can't be just brushed aside by saying he's in just because he's part of a group. Now then, my lord, I'm again not troubling my lord in the next section under direct relationship. I've given indication of judgments of other countries which have not accepted the single economic entity principle. So England has not accepted it, Bank of Tokyo Karun, Singapore has rejected it. And Singapore has rejected it on the grounds which I've set out in para 75. That one, it would be anathema to the logic of consensual basis of an agreement to arbitrate. B, ordering of companies within a broader group did not mean that one could dispense with separate legal entity. And C, if the doctrine was accepted, all one-ship companies would be considered as part of the same single economic entity, resulting in the liability of a one-ship company being visited on several or all of its other one-ship sister companies. Now, Singapore is one of the most forward-looking pro-arbitration jurisdictions, but it has not accepted this. England, of course, your lordships know, in Roussel and Searle, wholly owned subsidiary was not held to be part of the arbitration agreement. Was held to be a party. And Swiss law also, in para 77, the fact that one legal entity controls another is not sufficient to reverse the presumption that only the entity that Vodafone, then I've cited, I've shown that my lords are familiar with. In para 79, a passage from Gary Bond, which is also instructive, and I'll just quote it from here. All of this is found in my convenience, I'll just quote it from him. Quote, Gary Bond provides that the group of companies doctrine provides that a non-signatory may be bound by an arbitration agreement where a group of affiliated companies exists and the parties have engaged in conduct such as negotiation or performance of the relevant contract or made statements indicating the intention assessed objectively in good faith that the non-signatory be bound and benefited by the agreement. It's not enough to have a group. And this is a very important factor which is often despite tribunals heated in India. It's just not enough to just see a group. We have to satisfy further requirements of consensus ad hoc. Then, my lord, I won't trouble my lords to read the commonality of subject matter and composite transaction. My lords, that's the principle in Olympus superstructure. You have a mother agreement, ancillary agreements. Cloro controls in para 73 has adopted that. But going to the next page, page 21, the participation, the predominant participation of the non-signatory is critical. So, Dow Chemicals we have seen. Para 85, Redfern and Hunter. Question is whether the non-signatory actively participated in the conclusion and execution of the contract containing the arbitration agreement. And your lordships have also, in Reckitt, Cheran and Canara Bank, considered these factors, such as negotiations, execution, performance, as key determinants of intent. Of course, every case will be on its own facts. I'm not for one moment suggesting that will not. And therefore, the involvement of the non-signatory in the negotiation of performance should be such that the non-signatory has actively assumed obligations of performance upon itself under the contract or chosen to be bound. then one can say there is an implied acceptance under the contract, by contract. But a sentence here or a sentence there referring to the non-signatory can never satisfy the test of implied acceptance under the contract. And in Dalla's case, which I've earlier shown, but this passage I had not shown, but I'll just read it from here. Para 88 I've quoted. Dalla goes into this question. The UK Supreme Court says, one, subjective intention based on objective evidence must show a conscious and deliberate act of involvement. And two, additionally, if direct involvement in the negotiation and performance of the contract is by itself said to raise the presumption of a common intention that the non-signatory should be bound, it set an unworkable low threshold which would raise a presumption that many third persons were party to contracts deliberately structured so that they were not party. So, by merely saying involvement in negotiation and performance, in fact, you may defeat the whole intention of the contracting party, because it may be one thing when they enter into a contract. After a few years, one of the parties wants to make some claims, may suddenly decide to the contrary. But he must be bound to his election at the time of the execution of the contract. He consciously left out some companies. So all this has to be seen. And the test ultimately boils down to this. Are these factors or circumstances enough to impute an implied unconditional acceptance by the non-signatory of the arbitration clause? If they are not, then you can't draw in a non-signatory merely because it's part of a group of companies. And therefore, in para 92, for example, I've given some examples of the other way. So one would be mere incidental involvement in contract negotiation or contractual performance is insufficient. That's from Gary Bond. I've quoted from there. Then next in B, companies' awareness of a contract, including an arbitration clause between other parties, and its confirmation of one aspect of the underlying contract does not necessarily make the company a party to the arbitration clause. Let's take a case where a company A, which is part of a group, enters into a contract with company B. Company A takes on a variety of obligations under the contract. One of those obligations is stated in the contract that it will be performed by company C, which is part of the group. That doesn't make company C a party to the arbitration clause in the contract, because it can't be said that party C, by its conduct of doing one aspect of performance, has accepted that it is a party to this contract. Therefore, again, case by case. And a non-signatory without any causal connection with the process of negotiations cannot be made a party. These are not my ipse dixit. I've taken them from commentators. I've just gathered them together in one paragraph. And I've footnoted where I'm not troubling my lord with the next 2 pages, which is all the various theories. And in fact, when I read my learned friend submissions, there are many more. There's some 10, 12 theories. They're always theories. But each one has its own safeguards, qualifications, etc. Then we come to page 25. I've sought to answer the questions posed in Cox and Reeds. The first question A, whether the phrase claiming through or under in sections 8 and 11 could be interpreted to include the group of companies doctrine, and whether the group of companies doctrine should be read into section 8 of the Act, or whether it can exist in Indian jurisprudence independent of any statutory provisions. For the reasons set out in paras 50 to 58, persons claiming through or under in sections 8 and 45 cannot include the group of companies doctrine. The phrase is restricted to derivative claims, and the cause of action must vest only in the signatory party. That I'd covered on the last occasion. Then question B, whether the group of companies doctrine should continue to be invoked on the basis of the principle of single economic reality. It is submitted that the doctrine should not continue to be invoked on the basis of principle of single economic reality alone, for the reasons set out below. First, multiple jurisdictions have rejected the concept of single economic entity on the ground it vitiates the most fundamental principles of company law. In India, piercing the corporate veil, as stated above, is subject to satisfying certain stringent conditions. Second, the group of companies doctrine being a consensual theory is premised on the existence of a dispute arising from a defined legal relationship and mutual intention of parties. Sans intent, the application of group of companies cannot be invoked. Third, the jurisprudence around group of companies has entirely ignored the concept and definition of a group, and will not have referred to the accounting standards, where the group is defined as a parent with all its subsidiaries, and subsidiaries in turn is defined as an entity, including an unincorporated entity such as a partnership that is controlled by a parent. Control refers to the power to govern the financial and operating policies of an entity so as to obtain benefits. So it's not merely shareholding, it's to show actual control. I've also referred to the RBI master direction on this. And then para 103. Given the broad definition of group companies and control in modern day complex group company structures, a network of multiple entities across jurisdictions, one common ultimate parent or common parent shown at the top, may all be categorized as group companies, despite the fact that they have their own independent management and operations. The concept of a single economic entity may be viable in case of small family group structures, but would not stand water when looking at large group structures and transnational corporate groups. It is therefore not in line with today's economic reality. Otherwise, corporate structures that are common would automatically result in numerous companies being joined to arbitrations concerning just one or a few of the group. And this would render arbitration completely inefficient and unwieldy and undermine the independence of the legal entities and their party autonomy. Then, 105 I've already dealt with in detail about the promoters. I'm not repeating it. At 107, my lord, I've referred to the test of tight group structure in the MTNL case. Again, saying that can't be the sole basis. That may be one of several factors, but that really can't be the sole basis for imputing the group of companies doctrine. Then page 27, question C. Whether the group of companies doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties. Whether the principles of alter ego and of piercing the corporate veil will alone justify pressing the group of companies doctrine into operation even in the absence. Ranging from one of the first expositions in Dow Chemicals to chlorocontrols and Cheran, throughout the literature enunciated by Russell, Bourne, Redfern Hunter, Hanushu, across the law propounded in various developed jurisdictions globally, the key theme that runs through group of companies is mutual intention. My lords have seen that. Therefore, group of companies must continue to require this key element. It can't be discarded. Implied consent or mutual intention, what I've referred to in para 109, that is of all signatories and non-signatories. In 110, it is, as my lords have held in Cheran, group of companies is distinct and independent of theories of alter ego and piercing of the corporate.
That's 112.
At page 28. Whether the group of companies doctrine is expounded by chlorocontrols and subsequent judgments is valid. Now here, I have suggested, my lord, that there must be cumulative conditions, including the condition added by my lord in ONGC is performance, involvement in negotiation and performance, which is not there in chlorocontrols. And mutual intention, again, my lord, I have said, language of the agreement is primary. A bit of a repetition, I don't want to, my lord, read this. Then, my lord, page 29, there is observation by Justice Suryakant that there's some contradiction in chlorocontrols, because in one paragraph, it is referred to as a clear intention of parties to bind both signatory and non-signatory. The next paragraph says a non-signatory. This is at page 30 of my note. I've given the extracted one. A non-signatory would be subject to the arbitration without their prior consent. But this would be only in exceptional cases. And I would submit there's no real contradiction there. Because when prior consent is referred to in the context of non-signatories, it obviously means implied consent. It can't mean by signature or in writing. So therefore, I don't want to trouble my lord with the rest. I've given a short answer, but really my submission is this, and I end with that, my lord, that it is critical to limit the doctrine. If my lords are minded to at all include it under section 7, it must be limited to the parameters of section 7, which is a concluded contract valid under the contract. It can't be otherwise. Otherwise, it falls out of the whole scheme of our law, both under the Arbitration Act, the Contract Act. Section 28 of the contract. and which would require unconditional vocal acceptance to be determined even by. I'm deeply obliged. I'm
Thank you,
sorry
Mr.
I've taken a
Kamat.
little more time than I thought I would
Yeah,
have.
my learned brother has a question.
Of course.
Could this also lead to opening up at the behest of a third party innovation?
It's a very good question. My lord is right. A third party who is not a signatory can say either that it is a party to this contract or that there is a separate contract which replaces this, which is innovation. All sorts of complications could arise.
So it can, according to you, provided it satisfies 7 and 30,
Then it would have to still satisfy the Contract Act test.
an open end.
It would really open up. My lord is absolutely correct. It would really take it far beyond what was intended.
Therefore, this definition of contract being a written contract has provided.
But there is one caveat I might add, my lord,
have
to
a
my
role
answer.
to play.
There's one caveat that if it's a ratio, then even the arbitration clause is novated. Then he would have to prove that the novating contract has an arbitration agreement. So a full-fledged novatio may then, in fact, undermine the whole.
Thank you, Mr. Bhatta.
Thank you.
Now, who will be addressing after this? Mr. Rai will begin first.
Lord, I appear in the first matter for the respondents, Lord, is a section 11 being filed by Cox and Kings against SAP India and SAP Germany. And Lord, I'll just quickly address my Lord Justice Simha's last question, Lord, because, and I won't take my Lord, your Lordships through much of the facts of our cases because your Lordships are deciding the matter on principle. But some illustrations would always help, my Lord, how these principles apply in the real world of commerce. And my Lord, in my case, in the lead case, my Lord, Cox and Kings entered into a license agreement with only SAP India in 2010. And that license then, my Lord, grants them whatever softwares they want to get as licensees. It has an arbitration clause. And since it's a license, the arbitration clause is an ICC institution arbitration clause and says that the arbitrators, other than the chairman, shall be persons well versed in computer science or technical aspects of the law. It's got a specific qualification for the arbitrators. Now, under that license, Cox and Kings licenses various softwares from time to time. A wholly separate agreement is entered into 2015, where they license one more software from SAP India and want the services of SAP India to install license. That services agreement is also only between SAP India and Cox and Kings. Specifically says it's an entire agreement. Has a very different arbitration clause. Now, the disputes are SAP India actually commencing an arbitration against Cox and Kings. Cox tries to resist that arbitration, saying that the agreement is null and void, the services agreement. Then Cox and Kings goes into insolvency. And 2 days after it goes into insolvency, it commences an arbitration arbitration under that very services agreement it said was null and void against SAP India and also now SAP Germany. And it says it is commencing it against SAP Germany because at some stage when the services agreement was completed, one official of SAP Germany wrote an email saying we'll try and address the problems. And Mr. Advani, that email, according to him, meant that SAP Germany has taken over the contract. That's one of the digest to start this because in substance what they're arguing is some type of performance, in this particular case, an email written by one official novates the contract in favor of SAP Germany. I hope I make myself clear.
Yes.
And they reach, my lord, as my lord just said, my lord, This is very, very open-ended. In the context of agreements that are subject matter of has entire agreement clauses. The clause says, my lord, it's an entire agreement. The agreement also, my lord, your lordship, 16 times without number, says it can be amended only in writing agreed to between the parties. I'll show those kind of illustrative agreement clauses. Because, my lord, fundamentally what is being argued, my lord, is that the agreement is now being amended or an implied term is being read in. And my respectful submission, my lord, as my learned senior friend, Mr. Sambhata, just briefly raised, the test for reading an implied term is a very, very high test. I'll come to that, my lord, from Nabha Power. The word business efficacy, my lord, Chief Justice has used in some. That is, my lord, when your lordship finds an arbitration agreement and then wants to give it business efficacy. So, my lord, in IS form, when your lordship use, your lordship says, please can't defeat arbitration agreement by just saying, and then taking it out of arbitration. But the context in which your lordships used business efficacy was, there is an arbitration agreement, and your lordships are trying to give effect to that arbitration agreement. Today, my lord, business efficacy is being used to say that parties which have not signed any agreement are somehow to be brought in, not by virtue of Section 7, my lord. I stand entirely with Section 7. You don't have to be a signatory. It can be incorporated by reference. But, my lord, the group company, as I understand it, goes much, much further than Section 7. It says that without following the procedures of Section 7, you can be a party to an arbitration agreement. How? By there being some commonality in the transaction. I'll come a lot to the details. But by there being some commonality in the transaction, agreements cannot be implemented one without the other. So, my lord, in many respects, my lord, almost like a party claiming through another, I take a lot of Mr. Kambata's submissions. A lot of his submissions, my lord, I adopt. But according to me, my lord, as an arbitration practitioner, trying to, my lord, set sound arbitral practice, that leads to the conclusion that Section 7 must be applied. The group company doctrine, my lord, may not be an appropriate doctrine to find parties to an arbitration agreement. Well, the way I propose to proceed is, there are, my lord, various issues at play here. My lord, where your lordships have already engaged with the issues, I would only state my point. But where, my lord, there is a different perspective I wish to bring, my lord, I'll bring that point. And I'll largely follow, my lord, my written submissions, even though, my lord, they have evolved through the course of your lordships here in this matter. My lord, the way I propose to proceed is this. I want to take your lordships, my lord, only to Dow Chemicals initially and chlorocontrol, because that is the fount of this doctrine. And, my lord, Dow Chemicals, I'll show your lordships, is applying French law, which specifically says there is no form of an arbitration agreement. And then I take your lordships to chlorocontrol to, my lord, examine whether chlorocontrol made certain persons party to the agreement by virtue of the phrase claiming through or under, or by incorporation of the agreement contained in the mother agreement to, my lord, ancillary agreements. I'll formulate that. But, my lord, after examining that, I will take this matter on a clean slate. Can, my lord, the doctrine find its place in our Arbitration Act, in Section 7, in 2.1, or even in 8 or 45? And, my lord, my submission would be that to do so would violate, my lord, the Arbitration Act, the Contract Act, and also the Companies Act. But the same result or a similar result may be reached by applying Section 7, by applying the group company doctrine. And one other aspect that has been touched upon, but not fully perhaps, is in these cases, are we talking about joinder of parties? Are we talking about consolidation of parties? Or are we in fact saying that some persons are necessary and proper parties. And therefore, my lord, even though they are not parties to the arbitration agreement, we must find a way to bring them here. And my lord, the submission is this, that there is no doubt, my lord, that we must give the Arbitration Act its full meaning. And we must, in fact, my lord, endeavor to reach an interpretation that makes India arbitration-friendly jurisdiction. Or more than that, my lord, a jurisdiction that supports commercial work, and including commercial dispute resolution. But my lord, with all humility and with all due respect, my lord, I submit that the group company law may in fact do exactly this. My lord, I don't want to, my lord, in a bench before I am, my lord, I don't want to, my lord, make this a partisan case of arbitration tonight. But my lord, it is a good example. It is a good example of a company sitting in Germany, not signing any contract. Not signing any contract. An email is authored saying we understand there are problems in services contract between SAP India and Cox and Kings. It will be looked at. Now, my lord, kindly appreciate, and again, my lord, my legislative friend made these points, my lord. This official by email cannot be, my lord, binding SAP Germany. Kindly see, my lord, the reach of what the group company doctrine in that sense may be proposing. And there will be examples and examples, my lord. I confess that there are some hard examples, and there would be examples across the, my lord, range. There would be, in a sense, a use of the group company doctrine. There may be a misuse of the group company doctrine. But my lord, the doctrine as formulated may not be susceptible to this kind of use or if I may, my lord, misuse. Because, my lord, performance is, when do we say, my lord, the company has performed the contract? In Dow Chemicals, my lord, the other entities of Dow Chemicals were actually distributing goods through that distributor, Saint-Gobain. Well, it was that corporate entity that was actually doing the distribution. It wasn't some parent company's official who just stepped in. And the same test would apply, my lord, for negotiation. Often, my lord, in negotiation, you would, my lord, someone from the parent company may also come. But the ultimate test is, if that parent company was going to be bound by the contract or the arbitration agreement, I appreciate, my lord, those are two separate inquiries. Why would the parent company not sign that contract? Or sign, or by an exchange of letters, or by incorporation, incorporate that arbitration agreement? But kindly see again, how does a parent company contract out of this? But other than its subsidiary signs an agreement. That agreement is an entire agreement. That agreement says it can be amended only in writing between the parties. Now, in that context, Lord, how is the parent even to contract out? Because it is never contracted in, is my respectful submission. So, my Lord, I want to say, my Lord, although I am contesting the group company doctrine, it is actually because I am not in that pro-arbitration. Unless there is clarity on who the parties are, of course, my Lord, Section 7 will come up for interpretation in cases before this Honorable Court and in other cases. But, my Lord, that Section 7 itself provides the clarity. Within that also there can be contest. But the group company adds a layer of, my Lord, uncertainty without, my Lord, in my respectful submission, any statutory basis. And, my Lord, the further submission I will make is that the Arbitration Act or the arbitration procedure should be agnostic to whom are the parties. It should not be, my Lord, that if I take my arbitration to the ICC institution, I get a different result as to who are the parties. Whereas if a party files a suit and a Section 8 is filed, a different result comes. Or under Section 11, a different result comes. And I would not submit that this interpretation, this application of the group company doctrines may in some cases lead to that kind of contradiction. Where, you know, if it's a SIAC arbitration, a different result would ensue. Whereas if it emanates out of India or in a second, a different result may ensue. And my lord, all this is also very relevant in the context of the Law Commission report. And the Law Commission report recommending the amendment to the definition of party and that amendment not being taken into account. My lord, your lordship would be aware that in the same Law Commission report also recommended the amendment to the definition of an award, include the order of an emergency arbitrator. My lord, the emergency arbitrator in its public, my lord, nicely commented in his emergency award that that was not implemented by the central government because that would be like gilding a lily. The arbitral award always involved in emergency. But my lord, this would not be such a thing. Given the definition of a party that does not include the words claiming through another. We have a definition of party that is different from the English article, which too does not accept the group company doctrine. Despite that broader definition of party, even there, the group company doctrine is not accepted. With that preface, and just 2 or 3 illustrations that this raised, I think, a basic case where it comes up, agreement between a principal employer and a contractor, and the contractor in turn subcontracts various aspects of his work. Now, both these agreements have separate arbitration clauses. In fact, when we appear for a contractor, sometimes there is no defense to the principal employer because our subcontractors indeed delayed work. It sometimes becomes a difficulty when you're appearing for a contractor sandwiched in that sense between a principal employer and a subcontractor. I'm sorry. But in my respectful submission to two separate contracts with 2 separate arbitration clauses. And therefore, the arbitrations would have to be and so, the last aspect of my submissions will be, judgments which have followed. Because in my respectful submission, Amit Lalchand may have gone one step too far where there were not even group companies where it was brought in. And so too MTNL, where Canfina was not a party to the arbitration agreement. I'll briefly take you through that. But Cherin was correctly decided because Cherin was deciding a case of Section 35 and when a person would be bound by an arbitration agreement. And there, Cherin, and I'll show that, was a clear nominee of the person who had signed the agreement. Cherin, bought the shares as a nominee. And similarly, the decision in ONGC versus Discovery was correctly decided for this reason, that ONGC was seeking to bring in a party on the basis of alter ego. Therefore, Mr. Lawson said that before you decide the Section 16 application of that party, you must hear ONGC's application for discovery of documents. So, in that sense, the result was the correct result. He said, establish that the counterparty to my agreement is the law of one other that seek to impede in this arbitration. So, the judgments that follow. But with that broad preface, my lord, and only because I'm the first to be arguing, my lord, against the group company doctrine as it were, my lord, I have also, my lord, and I will make submissions how it narrow. But in the first respect, the approach I would, my lord, commend to your lordship is that the very text in the reading of sections, your lordships would, my lord, deal with who is a so define the application. Well, just 2 or 3 words.
No.
Now you really, because you are the first person who's saying that, well, don't apply the doctrine at all.
Yes.
So maybe we can come back at at 2 o'clock.
But,
Tell us, what is your estimate?
both of us-
I'm always very interested. So how much time would you
we
like?
both felt we need an hour and a half each, will spill over into tomorrow.
So because you start at 2 o'clock, then at 3:30 you should be done today.
Yes, yes.
And yes,
And your lordship
Then-
give us time tomorrow. Otherwise, we had agreed, Lord, we would share time. If
And
your
then,
lordship wants us tomorrow.
but 3:30,
Yes.
when you start at 3:30, and then you can finish by about, say, 12 o'clock tomorrow.
I think that will be fine.
That should- And then
Nobody
that
else
wraps
on
up,
this side?
nobody else on this side,
I
right?
think Mr. Ghosh wanted to make, just very short submissions, if at all, Sanjoy Ghosh. And well, that's it on this side. And I don't think
He's
this,
not here, but.
Because we are rising. Because if Thursday is declared as a miscellaneous day for some reason, then tomorrow we'll have to wrap this up. And then we'll be able to wrap it up because the others then can give us a supplementary note or something.
501.1, you want to address.
Yes, yes, Mr.
Thank you.
Thank you.
Check.
Yes, Mr. Bank.
Lord, I had said I would briefly just touch on Dow Chemicals, just to explain its context, and then directly come to the chloro control. Dow, your lordship has seen, my lord, the distribution agreement designated Dow France for the delivery of the products. So, my lord, one of the non-signatories, as it were, Dow France, was designated in the agreement itself as one of the persons who would distribute the products. And therefore, my lord, we don't know all the facts because this is, of course, a redacted version of the award. But Dow Chemicals, France, as that legal entity, was distributing products to Saint-Gobain, the distributor. Now, my lord, it would stand to reason that that would be done through some written agreement. From time to time, the rates at which the goods were sold, the terms on which the goods were sold would either relate back to the distribution agreement or would otherwise have some terms. It's not in that context that an intention is gleaned to adopt the arbitration agreement contained in that distribution agreement to Dow France. But I hope I make myself clear, my lord. This is, your lordship has not put examples of legal relationships which would be non-contractual. And there would be, my lord, even in the corporate world, there would be some. I can't rule it out. But, my lord, your lordship may appreciate, my lord, typically in the corporate world, if a corporate entity is performing, it would be doing so on the basis of some writing. It would be acting under like a distribution agreement like this. Dow France would be distributing goods. Now, my lord, it's in that context that this arbitral tribunal found, my lord, that those non-signatories were also parties to an arbitration agreement. But, my lord, because the facts, the more relevant aspect perhaps of Dow Chemicals is that the tribunal records that they are applying French law. And that's very critical, my lord, because as I'll show, my lord, French law has no particular form for an arbitration agreement. And in that context, perhaps these tests of
It's really cool.
Yes.
and my lord, because my lord, Dow Chemicals, ultimately your lordships have to interpret our arbitration act. But I only wanted to, my lord, endeavor to persuade your lordships that Dow Chemicals is applying a different legal regime, which specifically does not have the equivalent of Section 7 of our arbitration act. And perhaps in that case also, there probably was a distribution agreement and purchase orders or something akin to that under that distribution agreement. in addition to the non-signatory being specifically named as a party that would distribute the products under that distribution agreement. Look, and as I said, French law contains no particular form. Now, my lord, I come directly to chloro control only to identify what are the contours of the group company doctrine as laid down in chloro control and where they derived that doctrine from or where they found it in our arbitration agreement. But if your lordship comes to my written submissions now, I'll largely go as per that, my lord.
Yes.
Doesn't my lords have it, my lord?
You want to refer to chloro control now?
No.
I'll refer, my lord, to parts of chloro control and also my
Submissions.
yes. But if your lordship has
No,
first
see,
my
one thing
submission.
which the nodal council should have done was, in the earlier CBs, what they have done is that they have they've labeled the submissions A, B, C. So then it becomes easier for the council to say, okay, I'm on C2 or C3 or whatever. Otherwise, it becomes 1 second. I'm just trying to locate your submission.
Respondent SAP, last one. Written submission.
In the morning of
Respondent SAP.
This part goes like these written submissions set out the positions and respond number.
I'm
2.
grateful. Yes, that's our submission. I was placing chloro control. And my submission is that chloro control carefully read may actually be a case of consolidation of disputes.
Let's see how you formulated it.
Yes.
You can read through it.
Yes. May I, paragraph 3. of my written submissions. Does my Lord the Chief Justice have it?
Why don't we look at para 2 as well? You just take 2 minutes. So you have
Yes.
set out the facts. It just gives us the
Your Lordship has, my Lord?
Roman para 2.
Yes.
Ah, you're right. Para 3.
Yes.
You're right.
I'm
You're
sorry.
right. Para 3.
Heading para 2, Roman para 2, I'm sorry. And I'll just read it first and then explain my submission. In order to appreciate the group of companies doctrine as involved in chloro control, it's important to set out certain facts of that case. The plaintiff in the suit, that is chloro controls, was undisputedly a party to the arbitration agreement. Several of the defendants were party to one or more agreements, and all the defendants consented to arbitration during the course of the hearing. Out of the 7 agreements executed between the parties, 3, including the parent agreement, contained an arbitration clause. And no party had commenced any other proceedings in respect of any of the ancillary agreements. So, my lord, the ancillary agreements had separate arbitration clauses, and no party had commenced arbitration under any of those. And all parties, all defendants consented to arbitration, even those who were not party to any agreement that contained an arbitration clause. On the basis of the above facts, the doctrine was evolved, relying on the term claiming through or under in Section 45 of the Arbitration Act. However, as the ancillary agreements were appended to or explicitly referred to in the parent agreement, this court also found that the dispute resolution clause of the parent agreement had been incorporated by reference as contemplated in Section 7(5) of the Arbitration Act into the ancillary agreements. This is, my lord, extremely important because perhaps part of the reasoning of chloro was that relying on Section 7, the arbitration agreement contained in the joint venture agreement had been incorporated by reference into, my lord, the subsidiary or subsidiary agreements, my lord. But now I'll request your lordship just to read 3 or 4 paragraphs of chloro control to see how this doctrine has been laid out as distinct from what parties to an arbitration agreement are or can be said to, my lord. If your
Why
lordship,
don't we actually complete reading this part?
Yes.
Then we can go there so that
Very
this
well.
part is over, isn't it? That's better. So that your formulation is clear to us.
Very well.
To know where this was.
yes, ma'am.
Para 5.
In chloro controls, the court noted that normally arbitration takes place between the persons who have, from the outset, been parties to the arbitration agreement and the underlying substantive agreement. However, arbitration with a non-signatory to the arbitration agreement and the underlying contract is possible if the non-signatory claims to or under a signatory. The court thereafter provided illustrations of a party claiming through or under, such as assignment, succession, novation, and piercing the corporate veil. The illustrations do not include application of the group of companies doctrine. And your lordship will kindly have note footnote 1. The illustrations where a party is claiming through or under would often be defined as parties in the agreement itself. Your lordships have seen, my lord, when a party is defined, it sometimes includes their permitted assignees
Yes.
or successors. The submission therefore being made, my lord, is that these categories of parties or of persons would actually be parties to the agreement also in most cases. My lord, for example, an assignment. A permitted assignee by the definition contained in the agreement itself will be a party to the agreement. And it was even, my lord, in the Cheryl Properties case. And similarly, my lord, if a party succeeds to the rights of another party, my lord, if there's a merger of 2 companies, the successor entity will be bound, not just by law, but by the contract itself. The contract would define party means X and its permitted assigns or successors. Similarly, my lord, the test of novation. And finally, even piercing the corporate veil. Lord, if your lordships are piercing a corporate veil, your lordships are saying that although A has signed the contract, actually you can pierce the veil and go up to the parent of A. Similarly, submission is that these illustrations are, my lord, of a different category than the group of companies doctrine. These would, my lord, legitimately fall either as parties to the agreement or claiming through or under. But these do not include, my lord, the group of companies doctrine. Then, my lord, paragraph 6. In paragraph 71 of chloro control, this court recorded that though the scope of an arbitration agreement is limited to parties who entered into it and those claiming under or through them, the courts under English law have in some cases also applied the group of companies doctrine. Millard, I've put a footnote here also, Millard. I think it's common ground among all counsel, Millard, that this statement may not be entirely correct, that English law also does not recognize the group of companies doctrine. Therefore, according to Chloro Controls, the group of companies doctrine entails extending the reach of the arbitration agreement to persons other than signatories thereto and the persons claiming through or under them. While the illustrations set out in paragraph 70 of Chloro Controls would cover persons claiming through or under a party, the group of companies doctrine is something more. The court explained the doctrine as follows. An arbitration agreement entered into by a company being one within a group of companies can bind its non-signatory affiliates, sister or parent concerns if the circumstances demonstrate that the mutual intention of all the parties was to bind the signatory and non-signatory affiliates. So, in the first instance, the test was laid out in paragraph 71 as one that has mutual intention. It was based a lot on intention. Thereafter, para 8, Chloro Control provides two alternative bases for invoking the doctrine. These are the underlying transaction is with a group of companies, and there is a clear intention to bind the signatories as well as the non-signatories. This is again not intent. The second broader formulation was, despite the non-signatory not having consented to being bound by the arbitration agreement, it is joined as a party to the arbitration if it has a direct relationship to the signatory party, there is direct commonality of subject matter, the agreement between parties is a composite transaction, that is, performance of the mother agreement is not possible without execution and performance of ancillary agreements, and such joinder would serve the ends of justice. It is not this second formulation that was perhaps extended in Amit Lalchand to even a non-group company situation. And in my respectful submission, the group of companies doctrine is a bit of a misnomer. Because if your lordship finds intent to arbitrate, then group company or not,
It's a contract.
a party would be bound.
It's a contract then, because once there's an intent,
Yes.
then the question is, how do you, what is the evidentiary test for finding the mutual intent?
Yes.
Then Mr. Kambata just argued in the morning that, well, it has to resolve itself into a contract
Yes.
in terms of section 7 and 13.
And the
It
fact
can't be really just an intent dehorse any written contract between the parties or written pleadings or written correspondence in view of our section 7.
And in the context of group companies, that may be one indicia, that may be one indication. But ultimately, the test would still be, is there an arbitration agreement formed as contemplated in section 7? And that's what I'm saying, in some senses, the group company doctrine is broader than even the word suggests. I mean, it could bring in non-group companies also. So the fact that it's a group company is one indicia, but it need not be limited to group companies alone. If there is a document incorporated by reference, even a non-group company will.
Actually, even point number 2 can resolve itself into mutual intent, you see.
Yes.
For instance, if you say that, well, there's a direct relationship with the signatory party, direct commonality of the subject matter, the agreement between the parties is a composite transaction.
Yes.
The performance of the mother is not possible without the execution of the ancillary agreement. Possibly there are elements of intent here also, but then the court goes and says that such joinder would serve the ends of justice.
Yes.
It's almost like an Order 1, Rule 10.
And that's what I was saying. This is a problem arbitration law faces as to necessary and proper parties. That is really somewhat at the heart of this dispute, of this issue your lordships are also dealing with. But ultimately, there may be no easy solution when parties have expressly not entered into an arbitration. But I'll just develop that and section 8(3) of the Arbitration Act, which hasn't been dealt with in detail as yet. But your lordships are right, Lord. Order 1, Rule 10 would apply to civil court. But it may not apply, or in my respectful submission, it ought not to apply, Lord, to bring a party that is, and again, Lord, I'm prefacing all this by saying that would be, in a sense, not defeating the sanctity of arbitration agreements and an arbitration law more generally, because it is founded on consent. And your lordships have not expected that once there is an arbitration agreement, your lordships will give full play to it. The courts will not intervene except to the limited extent provided in the Arbitration Act. In section 34, your lordships have laid down an extensive jurisprudence.
So the essence of arbitration is that parties will enter into an agreement.
Yes.
With regard to who
Yes.
they will resolve their disputes with through a private forum as opposed from a public forum.
Yes.
That's the essence of arbitration.
I'm very brief.
It's not just that I, as a contracting party, want a private law forum as opposed to a public forum in the form of a court, but I also define with whom I want to enter into that transaction
Yes.
for a resolution of disputes through a private forum as opposed to a public forum.
I'm deeply obliged, Lord.
So it's not just the choice of the means of dispute resolution, but the choice of the parties with whom I will have that form of dispute resolution. In a court, that is not so.
Yes,
Court, the distinction between court and arbitration arises in only in terms of that a court is a public forum.
Public forum.
There's no choice, section 9 CPC
yes,
or 226 or 30. There's no option. Once one party goes, other has to come and the court will exercise. In an arbitration, you are choosing the forum.
yes,
That's the point of distinction.
yes. And Milord,
You are
choosing
choosing the
person-
forum, choosing the person with whom you will have the forum.
I could not have put it better, but that's the heart of my submission, that when your lordships find
Second part of it.
parties have,
Rising,
I'm grateful, yes.
whether you can go beyond the written parties or not.
Yes, Milord, and I'm submitting, Milord, and I hope to develop it. That exactly what, Milord, your lordships are putting to me, Milord. It's not just the choice of forum, but it is whom you will arbitrate with.
In a very about the kind of person they would like
Exactly.
the matter to
Yes,
be adjudicated.
exactly.
Yes. Well, therefore, all aspects. First of all, who will I arbitrate with? And then who will my arbitrators be? As I said, Milord, in my two agreements, the first agreement, Milord, specifically says that the chairman shall be a solicitor and the other arbitrators shall have a background of training in computer law, computer science, or marketing of computer industry products. Now, can this be clubbed with another arbitration that has a more general arbitration clause? I'll come to that, Milord, because that will raise serious concerns with regard to how institutions conduct their arbitration. Milord, and I'll come to those rules, because at the heart, Milord, as I try to submit, is some issue of joinder.
So it's layered actually. Parties agree firstly that they will not go to court,
Yes.
that they will go to an arbitration. Second, they will decide who will the adjudicator be in the private arbitral forum. What will be the qualifications for that arbitrator? You're not bound to select anybody. You can say, well, I'll have only a chartered accountant. I'll have only a structural engineer. I'll have only a whatever. You can define the person who's going to. So you have a choice of forum, the exclusion necessarily of the court. Second, the choice of the adjudicator in an arbitration. And third, that you will also be entitled to define who will you arbitrate with.
Yes. Yes.
That we will not agree to an arbitration beyond this set of parties
Yes. And
for whatever reason.
yes. Milord, I'll come to it, but since your lordship is putting it to me, Milord, those persons you are going to arbitrate with have certain rights under the arbitration agreement to, for example, nominate arbitrators. To take a simple example. Now, when Milord, in the group company doctrine, if parties are added, what happens to the rights of those parties? I hope I make myself clear, Milord. Milord, I'll show that through reading, Milord, the standard arbitration clause. Really, what is happening is an implied term is being read in, where in place of parties, the words are being added parties or certain group companies.
Mr. Rai, therefore, the point, really the compass is twofold. Either we jettison the doctrine completely, which is your broader point, or alternately, we so structure it so as to bring it within the comport of our Arbitration Act.
Yes.
If we have no choice but to jettison it, certainly. But considering the fact that, the doctrine has held a field and has worked itself out now for a decade, the other option is to sort of define the contours
Guardrails.
and guardrails, as Mr. Sambata said.
Yes. Milord, I'll endeavor to, Milord, even Milord, to, as your lordship defines the guardrails, Milord, I'll make my submissions on 8 and 45 and 7 so that those guardrails can then be correctly laid down, Milord, as per my submissions also. But your lordships are right, Milord. If your lordships find that the group company doctrine has a place in Indian law or in the Indian Arbitration Act, then a reading of section 7 and 8 will at least lay down the correct parameters for that doctrine.
All right, let's complete reading this 9
Yes.
and 10 now.
Well, at paragraph 9, the court concluded that though not all parties to the list are signatories to the arbitration agreement, they would be covered under the expression claiming through or under, as their interests are not averse to the interests of the principal company, and they derive their basic interest and enforceability from the parent agreement, with the other agreements falling in line with the contents of the parent agreement. Now, your Lordship has dealt with this expression in Charon Properties, where we're not claiming through or under, or in that context, claiming under, is you have to claim in the same identity as the person through whom you're claiming. Chloro Control places it as if there is a joint venture agreement and the signatories are signatories to other agreements under the joint venture agreement, a distributor agreement or a trademark license agreement. They are claiming through and under. That may not be with respect to correct test. You have to be claiming through or under the party, not through or under some agreement. And this becomes important because these agreements are the result of complex negotiation, of course, have their own separate arbitration agreement. And these entities tomorrow could be outside the group company also. Tomorrow, my lord, these entities could be sold by the Severn Group or the Chloro Group. They are always not separate legal entities entitled to their own rights under their respective agreements.
Let's quickly now go on to point number 3. This
Yes.
is your attack on Chloro now.
Yes. But may I just go directly to point number 5 first and come back?
Point number 5.
Yes, that is at page 6. I'll just deal with Chloro, and now I'm dealing with whether this doctrine can be found in 8 or 45, and then I'll deal with whether it can be found in.
Actually, why don't you read you've done it properly, actually.
Yes.
No, let's go back to your Roman 3.
Yes.
You've evolved it logically.
Yes, very good. But what I've tried to submit in Roman 3 broadly is,
Let's go read.
yes,
Let's read.
arbitration is based on consent and party autonomy. But section 9 of the CPC provides that all civil suits shall be subject to the jurisdiction of courts, except where there is an express or implied bar. As held in Dhulabai versus Madhya Pradesh, jurisdiction of the civil courts is all-embracing, except to the extent it is excluded by an express provision of law or by a clear intendment arising from such law. An ouster of the jurisdiction of a civil court is not to be lightly inferred. I don't need to place that judgment. I've just extracted the relevant principle. Because this is the guiding principle which ousts. Yes. Section 5 of the Arbitration Act contains that bar to the jurisdiction of civil courts. It ousts the jurisdiction of civil courts in matters, Lordship may mark, governed by the Arbitration Act, except where the Arbitration Act so provides. Lord, the submission was, Lord, that Section 5 ousts the jurisdiction of civil courts in respect of matters governed by the Arbitration Act. Therefore, my Lord, to say that there is no inhibition in the Arbitration Act to this doctrine may not be sufficient. It must actually be found in the Arbitration Act, because ultimately it ousts the jurisdiction of civil courts. And how does the Arbitration Act govern it? Is the parties' agreement to arbitrate.
The first sentence is important, para 13.
Yes, the parties' agreement to arbitrate as a condition to the ouster of jurisdiction of a civil court is therefore essential.
Which is section 28 of the
and section 28 of the Contract Act. Once the clear intention to arbitrate, as expressed in an arbitration agreement, has been identified, then arises the concept of party autonomy, which has been recognized as the cornerstone of arbitration by various decisions of this court. Given party autonomy, parties are free to choose the seat of an arbitration, the number of arbitrators, the procedure for appointment of arbitrators, the rules governing the arbitral procedure, the institution which will administer the arbitration, subject to the disputes being arbitrable under the law applicable. However, party autonomy is premised on the autonomy of a person to choose to arbitrate and with what my Lord the Chief Justice was putting to me. It is in order to ensure that the ouster of national courts is not lightly inferred in favor of a dispute resolution by a private forum, and to give primacy to consent and party autonomy, that the Arbitration Act prescribes the form an arbitration agreement must take. And my Lord, I have footnoted the decision in Charon Properties versus Kasturi, paragraph 24. That's my Lord, footnote 5 of my submission. I could read it, my Lord, if your Lordship wants me. Your Lordship have not laid down exactly that principle. Then, para 15, where commercial entities and persons of business enter into dealings, they do so with the knowledge of the efficacy of the arbitral process. The commercial understanding between parties is reflected in terms of the agreement between them. The duty of the court is to impart to that commercial understanding a sense of business efficacy. And there, my lord, I rely on your lordship's decision in IS1. But again, my lord, it is premised on a determination that parties have chosen to arbitrate and with certain other parties. Now, my lord, I deal first with section 7 and then with 8 and 45. The group of companies doctrine cannot be read into or from section 7 of the Arbitration Act. Consent to arbitration must be expressed through an agreement in writing. In a departure from the ordinary rule applicable to contracts, section 7 requires that an arbitration agreement must be in writing. This written agreement between the parties must be to submit all or certain disputes which have arisen or may arise between the parties in respect of a defined legal relationship, whether contractual or not. Section 7.4 sets out that an arbitration agreement is in writing if it is contained in a document signed by the parties or in the form of exchange of letters or other means of telecommunication or electronic communication, which provide a record of the agreement, or in the form of an exchange of pleadings where the existence of an arbitration agreement is averred by one party and not disputed by another. So, Your Lordship had noted that it can happen even post the dispute starting by the exchange of pleadings. But Lord 7.4, in my respectful submission, would be not exhaustive of the kinds of arbitration agreement and what it means for an arbitration agreement to be in writing. I'll try to explain later. While it is true that courts adopt a pragmatic and not a technical approach while construing an arbitration clause, this is only to the extent of not insisting that the agreement be in a particular form and not allowing the agreement to be defeated due to errors in drafting, such as misnaming of the arbitral institution or use of a particular nomenclature. In such cases, the court seeks to give effect to the intention of the parties. And these are my lord decisions that I've cited, Pricol and Govind Rubber. However, when the intent itself is absent, in that it has not been expressed in writing, a court cannot infer intent to create an arbitration agreement. And similarly, an arbitration agreement cannot be created based on the implied consent of a party or by reading into the contract an implied term. Or one learned friend on the other side said, an implied written agreement. That would be a contradiction in terms of my respectful submission. It would be apposite to refer to Section 9 of the Contract Act, which deals with implied promises and stipulates that insofar as such proposal or acceptance is made otherwise than in words, the promise is said to be implied. Considering that Section 7.3 of the Arbitration Act states that an arbitration agreement shall be in writing, the question of reading implied consent into an arbitration agreement to bind as non-signatory does not arise. So, that's why I submit, that implied consent, Section 7.5 certainly provides that an agreement can be incorporated by reference, but an implied consent may not fall within the requirements of Section 7, which define that an arbitration agreement should be in writing. But this takes us into an area that perhaps has not been covered earlier, because really what is happening if an implied consent is being read, then an implied term is also being read into the contract, into the arbitration agreement at least, for the first instance. Perhaps even in the substantive underlying contract, but certainly in the arbitration agreement. An implied term is being read that some other persons are bound by that arbitration agreement. And that's what I'm going to try to lay down the test in Nabha Power. In Nabha Power versus Punjab State Power Corporation, this Honorable Court has held that courts may imply a term into a contract only if all the following conditions are satisfied. It is reasonable and equitable. It is necessary to give business efficacy to the contract. It goes without saying, and it is capable of clear expression, and it must not contradict any express terms of the contract. But if I may just pause here for a minute and explain this point. Your Lordships have not an arbitration agreement, a typical arbitration agreement, that says any dispute or difference arising under this contract between the parties hereto shall be settled in accordance with the following procedure. And typically it says that party A will nominate, party B will nominate, and the two nominees will appoint a third person. Now, what is happening perhaps by reading in an implied consent is that arbitration agreement is being now subjected to an additional term, an implied term. And to do that, Lord, the test would be much higher than just business efficacy. Would be not these tests laid out, this Penta test in Naga Power, which is that an official bystander test, that anyone sitting in the negotiating room, if asked, is this non-signatory a party to the arbitration agreement, would say, but of course. Well, that is how the test has been first put down. Lord. That someone would say, but of course, there is no doubt about it, that a parent would also have agreed to be bound by the arbitration agreement. And Lord, I'm placing it a little high because your lordships are dealing with a range of situations which this doctrine will apply. But in the context of modern corporations, group companies, group structure, it is hard to conceive how an employee would be able to participate in a negotiation discussion and bind the company itself, absent it being a signatory to it. I place that because, again, Mr. Khambata has taken your lordships through the provisions of the Companies Act. Ultimately, a company will act through its board of directors. And a significant agreement would have to be authorized duly and signed. It would be very hard to imagine a situation where an employee would be binding his company without actually signing the contract. And that's why I tried to give an example of a arbitration clause in footnote 13, which is an arbitration clause between parties, the end of the second line. It's between the parties in footnote 13. And what is happening is parties are therefore being added. An implied term is being read, and that it's not just parties, but parties and certain group companies. The other aspect which involves a layer of complication is where a group company has signed a separate agreement with its own arbitration clause, then that arbitration clause is being negated and the arbitration clause in the mother agreement is being given effect to. Look, there are two situations. One is where the group company has not signed any other agreement or arbitration agreement. That may be one class of situations. But the other class is where that particular group company has specifically entered into an agreement with its own arbitration clause, as was there in Fluoro Control. Now, that arbitration clause is in effect being given a go-by. In effect, that arbitration clause is being given entirely a go-by, and that party is being told that you have actually acceded to or agreed to the arbitration agreement contained in the mother agreement. So, one of the guardrails I would respectfully submit is that even when applying this group company law, where a group company has entered into a separate arbitration, that arbitration agreement, where it has entered into none, perhaps mutual intent could be read to be part of the other arbitration agreement. But when the intent is actually expressed in a written agreement, including a written arbitration agreement, as was the case in Tribunal, that may be difficult to circumvent. I'll read on from paragraph 8. It is ex facie evident that given an arbitration agreement in writing, which addresses itself to disputes between the parties, this Penta test is incapable of satisfaction. In effect, under the guise of business efficacy, the arbitration agreement is sought to be rewritten, ignoring the clear terms of the written agreements, which are, especially in multi-party, multiple contract situations, the subject of long and hard negotiations. And again, I wish to draw a distinction between when your lordships have deployed the principle of business efficacy to give full effect to an arbitration agreement from this anterior stage, where your lordships are examining whether there is an arbitration agreement, and if so, among which parties.
No, Mr. Rai, we're talking about business efficacy. What about litigation efficacy? There is another contract, consolidation of the proceedings. That would also require us to apply the principle. I mean, may not be in this fashion.
Yes.
But otherwise also consolidation, if it's relating out of same kind of a, we have to find efficacy of the litigation is also a factor we have to take it.
But I bow down to that observation. There is a challenge. There is a problem. Well, the institutional rules also deal with this problem. They provide for consolidation of disputes where arbitration agreements are consistent with each other. Where, my lord, for reasons best known to the parties, they have agreed that a technology license agreement will be governed by the laws of, let's say, Germany, with a seat in Germany. But the trademark license agreement will be governed by another body of laws administered by a different institution. But the institutional rules would not permit consolidation. And my respectful submission, my lord, is that Section 8 is not a provision for consolidation. My respectful submission, neither is Section 11. And in doing consolidation under Section 8, my lord, we may be affecting the institution's ability to run its arbitration as per the arbitration agreement with the parties. My lord, I bow down entirely to what my lord Justice Roy is saying. There has to be, my lord, litigation efficiency. But that is also in large measure something to be determined by the parties when they are negotiating. They may provide for how a particular dispute will be resolved if it involves all the parties to the joint venture agreement and the other subsidiary agreements. But ultimately, my lord, the cornerstone of it may have to be, my lord, the parties' agreement itself. And if they have chosen a unwieldy or unwise in a sense process, that is, my lord, what they have chosen. My lord, your lordship put it well, my lord, that there may not be a soft solution to hard negotiations. Ultimately, these are hard negotiations. And, my lord, oftentimes, I may say this, my lord, with experience as being a corporate lawyer in my next years, there are reasons parties choose particular seats or particular institutions or particular applicable law. And my lord, in certain instances, perhaps the lord may not be respecting that choice as firmly as it should, my lord. Paragraph 20. Further, it is a set principle of contractual interpretation that previous negotiations and declarations of subjective intent included from consideration while interpreting the terms of the contract. Section 90 of the Evidence Act states that where the terms of a contract be reduced to writing, no evidence shall be proof of the terms except itself. In Rup Kumar versus Mohan Thedani, the Honorable Court recognized the written liberation on the part of the contracting parties, and it is natural that they should be treated with careful consideration, and that wherever written instruments either by the requirement or by the contract of the party, be the repository, any other evidence is excluded, be used as a substitute for such instruments or to contradict. When the terms of the contract are clear and ambiguous, only the express terms can be relied on. Therefore, where an arbitration agreement clearly sets out the parties thereto and the arbitral procedure agreed among them, no intention to bind persons other than the named parties can be read into the agreement. Similarly, where the underlying agreement contains an entire agreement clause or a clause providing that amendments to the agreement, if any, can only be made in writing, the arbitration clause cannot be interpreted in a manner so as to expand its reach to parties not named as parties to the arbitration agreement. And my lord, I've just footnoted at footnotes 17 and 18, just an illustration, my lord, what an entire agreement clause looks like, and my lord, what a clause with applications of the agreement shall be made except in writing. And my respective submission is, my lord, to the extent, my lord, the group company doctrine as formulated in Chloro Control, my lord, and I'll come to a narrower or prescribed version of it, my lord. But to the extent this group company doctrine as laid down in Chloro Control, it, my lord, goes against perhaps the written agreement of the parties itself. But as Mr. Lord, one of the tests that he laid down was that it should apply in reverse also. If a party can assert that it is a claimant under the, then it also has to be a defendant. In that context, Lord, I submit that you are therefore telling an opposite party that not just the party you contracted with, someone else can also lay a claim against you. And that, my lord, would be reading an implied term. But again, your lordship, with a myriad setting, there may be standard form of contract where this issue may not arise with its full force. But where, my lord, can be effectively put it, defining that only they will be subject matter of an arbitration. Then parties are an implied term is being added. My further submission was that if that term is added, it must be done on the principles of NABA. And again, we're speaking with all humility and some sense of responsibility, but it's hard in commercial contracts how that test can be, how it can not be contended. A parent sitting in the US tended to be bound by the other without even signing. After my submissions on section 7, I now come to whether this can be a principle found in section 8 or 45 of the Arbitration Act. Before addressing whether the group of companies doctrine can be drawn from section 8 or section 45, the scope or nature of the principle. Sections 8 and 45 are provisions in aid of arbitration. Right, how a judicial authority must act when an action is brought before it, that is the subject matter of an arbitration agreement. The provision is intended to ensure that if an action is brought on a matter that is the subject of a party or any person claiming through or under the party can be parties to be referred for arbitration. This legislative intent is also clear from section 40 and 41 of the Arbitration Act with the words. But section 8 and 45 are not which contemplate or can be read to contemplate the addition of persons as being found by the arbitration agreement. This is my respectful submission. These provisions do not purport to and cannot be relied on to alter the definition of an arbitration agreement as set out in section 7. That the constitution of an arbitral tribunal or the parties to the dispute are matters separate from section 8 is made clear on a reading of section 3. 8.3 makes clear that notwithstanding the pendency of an application under 8.1, an arbitration may be commenced or continued, and even an arbitral award made. But I request your lordships to just read that one provision with me. This has not been placed. Lordships has under section 8.3. Section 8.1, which is the application. Notwithstanding that an application has been made under subsection 1 and that the issue is pending, an arbitration may be commenced or continued, and an arbitration. Now, consider a control kind of situation where without one party under an agreement to which it is a party and that agreement has an arbitration clause. If it commences an arbitration under that agreement, before, for example, the ICC, it was the case in one of the agreements, then that arbitration would continue in just those parties. I hope I make myself clear. Because it is, again, I will endeavor to see how one can resolve the complex situation. But this is one complexity of the other nature that arises. The party which has a specific arbitration agreement is being denied the full effect of that arbitration agreement. And this is all done after negotiations between the parties. And this is not, I'm making a submission based on 8.3. Based on 8.3, that a party can commence its separate arbitration. And I'm partly responding to my Lord Justice Roy's comment that therefore 8 is not a provision for consolidation. So ultimately, consolidation has to flow from consent of the parties or the institutional rules deal. If their agreements are compatible with each other, the institutional rules will not provide for consolidation. But if you have neither consent of parties or compatibility of arbitration agreements, then there may be a certain and litigation inefficiency or dispute resolution. Separate from, I'm now on Roman 6 of my submissions. Separate from an understanding of the scope of Section 8, that it cannot and ought
It's
not
more or
be
less the same.
Yeah.
5 and 6 are more or less the same.
Yes. But 5 and 6, Milord, 6, I was trying to explain, Milord, that test of claiming through and under. Let us read that. As stated in section 2 of these submissions, the court in Chloro Controls relied on the words claiming through or under appearing in section 45, subsequently also inserted in section 8, to conclude that section 45 contemplates reference of non-signatories to arbitration. As stated above, the court in Chloro Controls recognized the category of persons who would be persons claiming through or under. These are persons who claim in the same capacity as the parties under or through which they claim, such as assignee or successor in interest. As held in Sharon Properties, the expression claiming through and under directs attention to the source of the right and is a legislative recognition of the doctrine that an arbitral award binds every person whose capacity or position is derived from and is the same as the party in the proceedings. Milord, there's a similar reasoning, Milord, in 20, which is the Australian. But your lordships in paragraph 20, Sharon, Milord, laid out what it is mean to mean acting through or under. The cause of action of such instance is derived from a party to the other. They do not claim an independent right based on the implied consent to the contract. However, in Chloro Controls, the persons sought to be brought within the ambit of arbitration were separate corporate persons who claimed independent rights under separate agreements. These persons were not claiming through or under the party, but rather claiming independently in their own right. Therefore, the doctrine of group of companies as articulated in Chloro Controls cannot be traced from the phrase claiming through or under. At the highest, it may be contended that parties to an ancillary agreement have incorporated by reference the arbitration agreement contained in the parent agreement on the basis that the parent agreement references the ancillary agreement or annexes a form of that ancillary agreement to the parent agreement. This is also part of the reasoning in Chloro. However, the arbitration agreement contained in the parent agreement can be incorporated into the ancillary agreement only to the extent that the ancillary agreement does not itself contain a separate arbitration agreement. Therefore, to the extent this was done in Chloro Controls, despite a separate, distinct, and different dispute resolution clause in a particular ancillary agreement, I just want to respectfully submit that even that aspect of the decision is required to be. Well, therefore, these are my submissions, first on section 7, then on section 5. But I'll rush through this next section, which is not that in earlier decisions, your lordships have articulated what it means to have an arbitration. And it's my respectful submission that that hasn't dealt with those decisions fully. Paragraph 13. We submitted that Chloro Controls is required to be overruled also because it did not adequately consider or contend with the previous decisions of this court on the subject. But in Wellington Associates versus Kirit Mehta, the court held that Section 7 of the Arbitration Act required the agreement must necessarily or mandatorily require the appointment of an arbitrator. Jagdish Chandra Milord, I may just come to the italicized portion. The intention of the parties to enter into an arbitration agreement shall have to be gathered from the terms of the agreement. And that if the terms of the agreement clearly indicate an intention on the part of the parties to the agreement to refer their disputes to a private tribunal for adjudication and a willingness to be bound by the principle of such tribunal and such disputes, it is an arbitration agreement. But I'm placing emphasis on the fact that the lordship held that to enter into an arbitration agreement, that intention has to be gathered from the terms of the agreement, not implied. It has to be gathered from the terms of the agreement. And the court further held that while there is no specific form of an arbitration agreement, the words used should disclose a determination and obligation to go to arbitration and not merely contemplate the possibility of going for arbitration. Then, your lordship, paragraph 34 was Sukanya. The court will distinguish Sukanya on the basis that at that time, Section 8 did not provide for persons claiming through or under. But at the end of paragraph 35, therefore, I make submission in the last 5 lines. It underscores that the court in Chloro Control relied entirely on the language of Section 45 of the Arbitration Act to justify the group of companies doctrine without considering whether such input is consistent with the definition of an arbitration agreement in Section 7. But there was a similar issue that arose in Indowind. And this was not in that case. The court also did not refer to or consider the wherein an arbitration agreement entered into by two companies was sought to be extended to a third company. Indowind, on the grounds that Subhuti was a promoter of Indowind and that the person who had signed the agreement on behalf of Subhuti was also a director of Indowind. The court objected these conditions, stating that if the director who signed on behalf of Subhuti was also a director of Indowind, and if the intention of the parties that Indowind should be bound by the agreement, nothing prevented Westcare insisting that Indowind should be made a party to the agreement and requesting that the director who signed for Subhuti also to sign on behalf of Indowind. This is in some senses the heart of the case, that there is nothing that prevents parties from insisting that that non-signatory sign the agreement at the relevant time. The court also dismissed the attempt to draw an inference that Indowind party to the arbitration agreement of the conduct of the parties, holding that while an ordinary contract may be entered into oral or spelled out from correspondence, the same cannot be said. The court held that if Section 7 says that an arbitration agreement should be in writing, it will not be sufficient for the petitioner in an application under Section 11 to show that there existed an oral agreement or that Indowind had transacted with Westcare or Westcare had performed certain acts with reference to Indowind as proof of an arbitration agreement. And I just want to spend a little time on this aspect, on performance. Again, performance must be performance of a corporate entity as a corporate entity. So we can't be without in my submission that just by an employee writing a letter or an email saying that I understand that the services agreement with SAP India has some difficulties, we are working to iron out those difficulties. That contract then is taken over by SAP. But therefore, performance.
The one, it said that we'll take care of the issue.
Yes,
Something to that effect.
yes.
So when you say take care, what would it mean that the subsidiary in India is not able to take care and will take care? Well, of course, you have said that it may not be a letter written by the company itself, but one of the person on the company.
Yes.
But then the person to whom the promise was made or the assurance was given, they would go by that understanding that the principal has said that we'll take care of the issue.
Tax security lordships are not going into that fully. Of course, the email originated from Cox and Kings. What that correspondence can mean, in my respectful submission, at the highest, is that we will look into how SAP India is executing this contract. Kindly similar, by that email, SAP Germany is not going to start receiving consideration for the contract. So the consideration that is flowing. Therefore, the entire performance is still by SAP India. Qua Cox and Kings. Cox and Kings has no relationship with SAP Germany. I dare say they have no contract.
That's right.
But they actually will not have no legal relationship, although that's a matter separate. That is a separate matter from the arbitration agreement. But what is being done in instances like that is really someone senior in the organization is saying that we will talk to our colleagues in SAP India and they will execute the contract. I hope I make myself clear.
No, I mean, we may not exactly go into the facts here
Yes.
and precise correspondence, but suppose the correspondence is such an issue which is arising between A and B, and C, which is the German parent company, C says that we'll take care of it.
Yes. Again, that is an email authored by a particular employee.
No, I mean, let's not go into
Yes,
precise the facts.
I appreciate it. But the submission that I leave it at that would what we talking there of an assignment of the contract or even a novation. And if that is what we are doing, then is that consistent with the terms of the contract itself? And it would not be consistent. That's why these issues would get a life of their own, in the sense that if this goes into an arbitration, but your lordship is aware we can't challenge the Section 16 dismissal. if section 16 is filed before the arbitral tribunal and comes to be dismissed, then you have to participate in the arbitration through its entire journey. And you can challenge it in section 34. And that's where, in some sense, the stakes are high. To not involve a party that is not a party to the arbitration agreement. And juxtapose with how do modern corporations transact? They transact through written contracts.
No, that
They
threshold has to be very high.
Yes.
First and foremost.
the US and Germany are providing services in India.
I mean, suppose the facts are such that yes, it could be understood as a novation of the contract. Believe or do
Well, the entire team working on it would still be SAP India. I'm only saying
no, that of course.
that may not be what the person also understands. It is still the issue. But the person with whom we are is still always SAP India. We're escalating the issue. Someone will look into it, but the understanding may not be that simple that by just a letter, you making it to SAP Germany.
In golfing terms, if you use a rescue
Yes.
to get out of this tricky situation, the German company is saying, I'll rescue. What happens?
But I would only say the German company is the caddy who hands you the rescue.
Okay.
But you have to still hit the rescue. And I'm only submitting this in the context of this issue will affect modern corporations. And if they were to make party to an arbitration agreement, which is a seat not chosen, procedure not chosen, that may have some consequences, separate from the fact of what this relation they have entered into with Fox and in this case. But if SAP Germany is faced with the situation, this case now not just that there's an arbitration agreement, but there is a contract or a claim against SAP Germany. And those are two separate issues, arbitration agreement and legal relationship. But the line is very clear. But ultimately, these parties that have made parties to the arbitration agreement to be made part of the main contract also. Ultimately, those are the claims that are being made. And I'm only respectfully submitting that would be done by a formal arbitration, in which case they would anyway be parties under the agreement, as well as paragraph 70 of the protocol. Where it is just a claim, it can't rise in my respective submission to the threshold of innovation or an assignment of the contract. So I'll just place 38 because MR Engineers has a nice formulation of appropriate guardrails, perhaps. Para 38. Reference was made in Chloro Controls to Section 7.5 of the Arbitration Act and decisions of this court to incorporation by reference. However, the conditions subject to which a clause contained in one may be to be incorporated in another. In MR Engineers versus Somnath Builders, the court held that Section 7.5 requires conscious acceptance of the clause contained in other document, and a general reference to the other document is not enough. The court also held that the court would have to examine whether the intention of the parties was to incorporate the entire agreement or only a specific portion thereof. The court summarized the principles related to incorporation as follows. General reference to a document containing an arbitration clause is not enough. A clear reference to the document containing the arbitration clause is necessary. The reference should indicate intention to incorporate the arbitration clause. Where a contract provides that its execution or performance shall be in terms of another contract, which contract also contains a provision for settlement of disputes by arbitration, the terms of the referred contract relating to execution performance alone would apply, and not the arbitration agreement contained therein, unless there is a specific reference to the arbitration clause. This requirement may not apply where the contract provides the standard form of terms and conditions of an independent trade or professional institution to bind the parties, and such standard terms containing arbitration clause. And 5, the arbitration clause sought to be incorporated should be capable of application to dispute sought to be incorporated. This decision further supports the conclusion of this court has always required the parties or a firm of agreement, absent which an arbitration agreement will not be preferred. And then, my lord, chlorocontrol I've dealt with, my lord, para 158, use this expression of incorporated by reference. In the face of a contradictory dispute resolution clause, that, my lord, reference may not be missed. And finally, my lord, paragraph 41. The court in to refer a non
Always go with best.
So how long now, Mr.
Lord, 15 or 20 minutes. I'm conscious of my time. Lord, I'll just rush through some of these points.
You address us more on seven. Seven
Yeah.
is a crucial part of it because
Yes.
everybody is focused on seven.
Yes, Lord, may I just go through this itself and I'll just complete in 15
Yes,
minutes.
yes.
Roman 8, Lord, of my written submissions
Yeah, that's right.
makes the point about the Law Commission recommendation.
That's right.
Right.
And Lord, at paragraph 45, I also narrate which other provisions of the Arbitration Act from party, which would all be impacted by this particular. Lord, I've already made briefly my submissions on the 4 cases, Lord, that are also concerned here, Lord, which followed chloro control. I'll just Lord, place on Cheran properties, Lord. If I may just read
Yes.
my discussion or my understanding of Lord Cheran properties.
Yes.
In this case, the court was considering a share purchase agreement which recognized the right of KCP to sell or transfer his holding in SPIL. This is important, provided the proposed transferees accepted the terms and conditions mentioned in this agreement. Similarly, the agreement itself contemplated a proposed transferee accepting the terms and conditions of the agreement. And it is pursuant to this share purchase agreement that KCP addressed a letter acting as the authorized signatory of Cheran and making a clear and categoric reference to the share purchase agreement, and that's paragraph 32. In that context, and examining section 35 of the Arbitration Act, which makes an award, arbitral award final and binding on the parties and persons claiming under them respectively, this court rightly, Cheran, the nominee of case, bound by the award, even if it was not a part of it. The decision, insofar as it refers to and relies on chloro, does so to negate the submission of the appellate, that is Cheran, that the group of companies doctrine cannot be applied in this case. It is in that context now that the court was asked to go into the group company doctrine. However, what is applied after the discussion of paragraphs 23 to 28 by the court, they was the group of companies if the phrase claim, because in this case, Cheran Property could only claim its right to the shares through KCP, who had suffered an award. So this is not.
So we held that Cheran is really bound by the award which was rendered against KCP,
Yes.
though Cheran was not a party to the arbitration proceeding.
I'm
Because Cheran had the KCP, KCP had assumed the right to transfer its shareholding, provided the transferee agreed to be bound by the same terms and conditions. And Cheran had expressly stated that it was bound.
yes. Yes. That
And
letter
therefore,
on
it had
behalf.
assumed, because it had assumed this contractual obligation.
Yes.
Then the award also bound it. That's what we said.
Yes, I'm grateful. But I'm grateful. But that's how I've understood that decision. And really, red herring of chloro control was raised, but actually it was a case of taking under because it was a assigning of. But Amit Rajchan has now adopted just the second part of that chloro control test. And merely because agreements are interlinked, parties have become bound by the arbitration agreement. And in this case, Milord, it was an unrelated party also. And therefore, Milord, I've submitted with respect, Milord, that decision may not be correct because Rawat has extended it purely on the fact that there are interlinked contracts. And Milord, I just read from line 8 or 9, the issue that may arise. Milord, line 9 or 10, Milord, this may best be illustrated with a simple example of a principal employer who engages a contractor pursuant to principal agreement. That contractor in turn engages one or more subcontractors under one or more separate subcontract agreements. Assuming the agreements contain separate arbitration clause, the mere fact that both sets of agreements relate to the same commercial project cannot be the basis to conclude that the subcontractors have agreed to be bound by the arbitration agreement contained in the principal agreement. To do so would defeat the expressed intent of the parties to be bound by that particular arbitration agreement entered into among them. And in the case of arbitration agreements that contemplate institutional arbitration, this would also impact relevant institutional rules of consolidation of arbitration. It would also have the effect of converting what would otherwise be a purely domestic arbitration into an international commercial arbitration, which in turn would determine whether the ground of patent illegality would be available to the parties to challenge the award. The submission here is when parties are, as in my case, SAP India and Fox and Keynes, then it's not a domestic arbitration. Now, if you bring in a non-Indian party, to use the term generally, then you convert the character of that arbitration also. And that's where I come from when I submit that agreement has to be read a little carefully. But MTNL, Canfina was not a party to the agreement to arbitrate, and therefore I submit, Lord, that decision may not have been made required to be overruled. ONGC versus Discovery, Again, my lord, so facts would be clear. In this case, ONGC had entered into a contract with Discovery Enterprises Private Limited, but brought an arbitral claim against EPL and a sister company, Jindal. ONGC also filed an application for discovery and information to make its case that there existed functional, financial, and economic unity between DEPL and JDIL. Without considering this application, the tribunal allowed JDIL for deletion. It was this section 16 set aside by the discovery application should have been decided first, especially as JDIL failed to produce tribunal's order was prior to this topic. The tribunal didn't have the benefit of fluoro control because it happened much later. Inasmuch as this was the basis for the decision of this, documents produced by DEPL may have made out ONGC's alter ego. And since the case was remanded on the basis the tribunal did not have the benefit of this court's decision in fluoro control, the decision may not require reconsideration. Well, just very quickly, fluoro control erroneously states that English law supports the group of companies doctrine. There's no international consensus on the applicability and extent of the doctrine. But I've reproduced the definition of party from the English Arbitration Act. I've reproduced that definition, and your lordship sees, my lord, references in this part to a party to an arbitration agreement include any person claiming through or claiming under or through a party to the agreement. And despite this, my lord, English law doesn't apply the group of companies doctrine. Importantly, my lord, Singapore, since it's such a pro-arbitration, also, my lord, rejects forced jointers. The words used in that judgment are that it's a drastic. Similarly, the United States. Para 50 and 51, my lord, I again just set out Dow Chemicals and explain that arbitral awards do not create a and also rendered under different laws that are not. Lord, paragraph 11 of my submissions, again, I won't spend too much time on, my lord, but I'll just read out the heading. The submission of the group of companies can be discarded only if the Arbitration Act expressly prohibits it.
That was Dr. Singhvi's sir.
Just read that by saying, my lord, that section 5 says as governed by this. And therefore, my lord, it must be found in section 7, 8, or 45. My lord,
Go to para 12, I think. That's your wrap-up.
Yes, para 12. Rejecting the group of company doctrine advances arbitral practice and provides clarity. The following principles emerge from the discussion in the preceding sections. Arbitration requires consent as to the party's intention to arbitrate. This consent is provided by requiring an arbitration agreement be in writing. The intention of the parties must be gathered from the words used in the contract, and where those words are unambiguous, their plain meaning ought to be given effect to. Where the parties have incorporated into the underlying contract an entire agreement clause, the parties' previous negotiations cannot be relied on to discern whether the parties had an intention to bind any third party to the arbitration agreement. Of course, where there is a principal agreement and ancillary agreements arising therefrom, the arbitration clause contained in the principal agreement may be incorporated by reference into the ancillary agreements, provided that the ancillary agreements do not contain any inconsistent dispute resolution clause. However, this does not require the invocation of the group companies doctrine. In such a case, reliance will be placed on section 7, 5, and the law laid down in MR Engineers. Under Indian company law, an agreement entered into by one of the companies in a group cannot be binding on the other members of the same group, as each company is a separate legal entity which has separate legal rights and liabilities. I rely on Vodafone. Mr. Kambata has already argued. Therefore, my conclusion, the group of companies doctrine is inconsistent with these principles and with the principle of party autonomy. Is submitted to the doctrine, or from advancing arbitral practice, in fact, detracts from it. This is because it introduces a significant element of uncertainty and discretion in determining the persons bound by an arbitration clause. Consequences of this uncertainty are significant. If a person asserts that it is not a party to the arbitration agreement, that person will have first to have recourse to section 16, and if unsuccessful, will have to participate in the arbitration proceedings before challenging an award under section 4. If it is then determined that it had not impliedly consented to the arbitration agreement, the award would have to be set aside and parties relegated to civil court for adjudication of their disputes. There may be no easy answers in disputes that arise in the context of multiple parties or multiple agreements. That is why institutional rules also have separate rules for consolidation of disputes or jointer of parties. Ultimately, though, the answer ought only come from the terms of the arbitration agreements entered into between parties, if the parties have entered into distinct separate arbitration agreements, or as in the case of chloro control, dispute resolution clauses that contemplate adjudication by a civil court, or if there are persons who are not party to any arbitration agreement at all, there is no basis to consolidate all the disputes applying in group of companies doctrine. It's therefore respectfully submitted that the doctrine ought to be held if not valid in Indian law. Well, let me just add one footnote. If your lordships consider the guardrails or prescribing or limiting the doctrine, my respectful submission would be that the second limb of chloro control, which says that when there is a commonality of the agreement, even absent this non-signatory consenting, principle can be employed. That part, my lord, may be too broad.
Right.
The first part of the chloro control test, my lord,
The mutual intent part.
mutual intent, my lord, can be read in only in those cases where the group company is itself named in the contract as a party and actually performs the contract as a corporate entity.
Right.
The Dow Chemical kind of situation. So, my lord,
Thank you so much, Mr.
I also appear in the matter that Dr. Singh appeared. But I also appear on the other side. And that's just one sentence on that. That arose from a deed of family settlement, which was between certain individuals of the Kirloskar family. Dr. Singh's client filed a suit arraying all the individuals and also various listed and unlisted companies of the Kirloskar group. So, in fact, they filed a suit recognizing perhaps that the group of companies doctrine would not capture this. They actually filed a suit. As it transpired, the companies whom I represent said, without prejudice to their argument that they are not parties to the family settlement, the contract, they are agreeable to go to arbitration. That is what we gave in the Bombay High Court. So actually, that case doesn't really arise here because, in fact, they've taken opposite position.
Right, we'll wrap up at this stage and we'll take up now.
One last statement,
Yes.
Kirloskar. As I said, that issue is the issue that Mr. Kambata addressed, whether individuals can bind listed companies. It doesn't really arise in this case. I just want to place that.
We'll start tomorrow with Mr. Diwan. Liz, you want to also argue? All right. You're instructing Mr. All right. So now the only submission left on this side is Mr. Diwan. George, you want to argue?
Intervention on national committee on that.
Oh, you are appearing for the answer to our national committee. So you will guide us dispassionately. You be like a really and a Michael Scurry.
Yeah, just 10 to 15 minutes.
And Manoj, there's Mr. Sanjay Ghosh who says he'll take about 10 minutes. He was here in the afternoon.
No difficulty. Mr. George, you can give us whatever material you have,
Yeah.
You have filed that.
I'll-
All right. You have circulated because Uncitral will have a lot of underlying material.
I mean, just about
we should be
model law
happy
and
to see that.
Relation with the New York Convention.
All right. So about half an hour for you tomorrow. Say about 11:15, 11 o'clock to 11:30.
For me,
Yes.
Yes.
Now I think we have heard substantial arguments.
I had in fact anticipated about an hour and a half. Your lordships had told me that your lordships would give me.
Now I think we'll wrap it up early because we have a special bench. We don't want to spill it over because next week we have another conference starting on.
Much of you can just indicate to us.
We have to close now.
I'll certainly will try because I kept on cutting my cloth based on what was said.
If you have a good night's rest, I'm sure you can
No, I certainly,
consolidate
I
further.
certainly will. If your lordship thinks I'm, I mean, I certainly don't intend to repeat anything that.
If you are tired like we are when we start dictating judgments, it will be very long.
Correct. But, so there are a couple of other facets which, in fact,
If you're fresh, that's what my learned say, brother says, then it will be brief and.
no, I certainly will. I mean, I don't think your lordships have ever seen me.
So half an hour and then
Because I need-
George 15 minutes for you.
Yeah.
Because can I
Maximum
just, because I'm certain I won't be done in half an hour. There are certain aspects of the.
20 minutes?
If your lordship is cutting.
Raman, yeah.
No, your lordships may give me at least an hour and a half.
At least,
I'm so grateful.